You're rocking with the best. 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 We're about to take it back. We're about to take it back.
Supreme Elite Team.
Session, yeah. What? Thomas.
They studying the source now. Supreme Elite. New Empire talk. Came on reading numbers, they were reading memes. We was reading filings, planning out the dream. Turn every late fee in the case all heat. Judge bang gavel, he don't skip a beat. They like how you flip stress into assets, how you turn a loss in the last check. Thomas took notes, broke codes, then he proved it. Now the classroom global and the language fluid. Thomas is the blueprint. Write that in the sky, let the crew print. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is the blueprint. Supreme Elite Team, that's the school stamp. From the first lay bill to the full camp. New culture empire, watch the flag plan. Supreme Elite Team University. Turn the credit score into currency. Turn the closed door to a first key. Turn the side job to a legacy. He beat odds, then he beat litigation. Now we teach law like a new translation. From confusion into consultation. From survival into foundation. They log in, lights on in their eyes now. Section this, call that. They reply now. He like, know your rights, then apply now. God, that's the real drip. Let it dry now. Thomas is the blueprint. Write that in the sky, let the crew print. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is the blueprint. Supreme Elite Team, that's the school stamp. Wave it. From the first lay bill to the full camp. New culture empire, watch the flag plan. From the bench to the block, he reversed that. Put the power in the pen, yeah, he birthed that. Every mind that he frees, that's a verse that. Whole culture on the rise, you can search that. Hey. Thomas is the blueprint. Write that in the sky, let the blueprint. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is the blueprint. Supreme Elite Team, that's the school stamp. From the first lay bill to the full camp. New culture empire, watch the flag plan.
Welcome to another live stream by the New Culture Empire. Yesterday, we had over 700 watchers across multiple platforms. Please take a moment and like the live stream from yesterday. And don't forget to subscribe, hit the notification bell, and share the live stream. We're on our way to 2,000 subs. Let's keep the culture moving forward.
Smoking that leaf, going global stand. On my wrist like a safe, they can't clench. You look like you wanna let go of stress. What's up? I thought so. Okay. I'm back in this if and you stuck on a man.
You're rocking with the best. You're rocking with the best. You're rocking with the best.
It is Tuesday, March. Somebody give me the date. I don't even be keeping up with the date. The 9th. 9th for the 10th, 2026. The 10th, 2026. Yesterday, it was a banger. Shout out to all 720 people that was in the building, which 98% were soft sits. Shout out to everyone who is still saying that I'm wrong. I got to shout out to y'all, man. I got it. Y'all very persistent. Now, of course, we like to be entertaining. And of course, we like to make it fun. Of course, we like to keep it serious. Of course, y'all know how social media and the internet is. You got to be somewhat of entertaining. Someone, got to be a little showman. You got to give something for people to watch. I understand all that. But besides from the other drama, which is subscribe to Drama News, got new content coming out this weekend. Oh, it's going to be drama. I want to talk about things that are actually going on in real life. Not saying anything else ain't going on in real life, but I believe that the things that I talk about is more, well, this is my opinion. I could be wrong. Anybody that talks about important topics can say the same thing. Let's just say we talk about things that affects people's daily lives every day. And the reason why we can't get around it is because unless you are a multimillionaire, unless you are independently wealthy, unless you have enough assets and resources to fund your own business, take the losses that comes with that, replenish the assets and infuse the business with more cash flow and resources, you're going to need financing. As a matter of fact, even if you are all of the above, it is more beneficial for you to get financing for your projects, even if you can pay for that stuff out of your own pocket. What is the benefits of getting finance? Now, I'm talking on a business scale. I'm not talking on a consumer scale, because there's nothing to talk about on a consumer scale, because everybody gets financing in that aspect. Everybody, unless you were inherited a house or things like that. Everybody gets financing. So everything that I talk about applies to everybody that's living in the 132 countries that actively participates and engages in securitization worldwide. It's a global thing. As a matter of fact, what I talk about affects not only individuals, corporations, business, the market, the secondary market, the treasury securities, all the way down to mortgages, autos, credit cards, all the way down to that. It affects from the top down. Why is that important? Why does that affect from the top down? Is because, as I said yesterday, if there wasn't any securitization that's going on, you would not be able to be in the home that you're in right now. You would not be able to be in that vehicle that you're in right now. Hey, if you had a choice to do it, then obviously I'm not talking about you. I'm talking about those who fill out applications with the sole purpose of getting into a financing, meaning you get the asset up front, because that's what securitization allows you to do. Securitization allows you to leave with the asset up front, and then you pay it back over time. Now, why can't we go directly to the investors themselves and structure a business deal with us? It's a plain answer. The system and the corporations and the financial institutions have cornered the market. They won't even talk to you unless you go through one of those securitization vehicles. It's a closed, small, netted thing. Individuals like you and I, we are not allowed in that world. I don't care how much exotic names you want to give yourself. I don't care if you claim that you're the beneficiary of a multi-million-dollar estate created by your social security number and birth certificate. I don't care if you call yourself executor, exetrix. I don't care if you call yourself fiduciary. I don't care any of the exalted titles you want to give yourself. The reality is you will never, as an individual or consumer, never be able to play in that world when it comes down to institutional investors and the secondary market and the investments into these structures. We're not talking about investment into securities that are produced from the structures. I ain't talking about investing in the structure itself, meaning you put $2.5 million of your assets up to receive Class A of the treasury or trust securities that were generated through the receivables. That's top level, top notch. You don't get that from the position that any of us are in. You're not getting that. You are not going to play in that world. Now, you can be one of the ones who invests in the securities that those structures produce. I mean, anybody can do that. Hell, you can go online, set up a Treasury Direct account, and you can start playing right there. You can invest in Treasury securities, but we're talking about the inner structuring of these things. And the inner structuring of these vehicles and the billions upon billions that flow through these vehicles on a monthly basis. Now you are dealing with a $16 trillion a day industry from transactions being conducted on the secondary market. That is way more than this country's total GDP.
You're rocking with the best.
Oh, I keep forgetting TikTok. This is why I don't like to be cammed up on TikTok, because I can't do what I want to do. So from, people that worked on the inside, like the 2008 bailout. Y'all remember that? What did they tell everybody the 2008 bailout was? Y'all remember when we talked about this? When they said, what was the stimulus package? 800 billion? 800 billion. Okay. Subtract 800 billion from 29 trillion. That is what they chose not to tell us. The banks, financial institutions, investors, top CEOs take home pay. They received 29 trillion from the government. 29 trillion. That was the real bailout number, because someone who was actually on the inside knew the real number. We got the more acceptable number in the public eye, which was 800 billion. Can you imagine if they came out and really told us it was 29 trillion? Can you imagine? So once you understand the inner dynamics, I'm near a military base, so they always flying over. I don't think that was military. I think that was a regular plane. Once you understand the inner dynamics of these transactions, you will understand that many people, and this is no offense, only know about 2%, maybe 1.5% of what's really going on. The well gets so much deeper, and the truth gets far more sinister as you go along. But when you start your transactions and your journeys right from where you're at, and you don't obtain the underlying, meaning everything that took place before you signed the application, you're still going to be missing key and important parts. And they know that you're going to be missing key and important parts of how this financial system works. And we're not just talking about your JP Morgans of the world, your Bank of Americas of the world. We're not talking about your JP Morgan Chase. We're not talking about your Wells Fargos of the world. We're not talking about none of just the regular financial institutions or your mortgage originators. We are talking about the Reeboks of the world, bicycle health and medical insurance of the world, chemicals production plants of the world. Every store that you shop to, whether it's for food and produce, hardware, shoe stores, Nikes, Yums, KFC, Popeyes, Home Depot, Lowe's, Apple, StreamYard, they all engage in securitization. All of them. So this is bigger than you and I. This is bigger than you and I. So I make the statement, this is a $16 trillion a day industry. You got to look at all the participants. Every day there's a registration statement. Every day there's a SEC filing. Every day there's a beneficial ownership filing. And for you beneficial ownership people, you people that like to talk that beneficial owner crap, you people like to talk that beneficial owner. Well, let me tell you this. You're not the beneficial owner of jack shit. You're not. No. I'm not talking about an equity you are. Because one of the problems that people don't understand when they want to raise these, I'm the beneficial owner in equity. Equity is only going to allow that claim if you were already legally entitled to the proceeds, not from an equitable standpoint, a legal standpoint. So if I was a registered beneficial owner, registered with the SEC, registered with the collateral agent, registered on the books, and they refuse to give me my pay, then I have an equitable claim. But if they were not legally entitled to pay you any proceeds from the securitization from the jump, you have no equitable claim. You see how that works? And I apologize. I'm sorry, but not sorry that 98% of people's claims I refute so easily. I just shoot it down with law. In fact, it's not me that's the villain. It's those people that are the problems who believe in these things. I'm not the villain here. I'm not the villain here. Oh, I'm not the bad guy here. But I will wear that role and I accept that role with pride and I will accept that role with grace. You want to know why? Because my mindset gets shit done. My way of doing things, which is following the rules and the regs, allows you to not go down the rabbit holes that you see people go down every day. And for the love of Christ, the way I do things allows for that thing right over there. You can park it freely and don't have to hide it behind that. And nobody's coming to take it. You see that? Nobody's coming to take that. That's legally owned by me. Title in the folder from my way of doing things. So keep that in mind. Keep that in mind when we want to start talking about who's right or wrong. Because the only way, once again, I keep sounding like a broken record. The only way you can determine if you're right is by the measurable results. Just like yesterday, we broke down Almaty for like 4 hours. We watched court case after court case after court case, everybody coming in court singing the same Almaty tune, and the judge shut them all down to the point where the judge was going to give one person a free PR bond, but he kept pushing that BS, and the judge made him come into court, and he had to bring $300 now. Being idiotic cost him $300. Now, $300 is not the end of the world, but it definitely ain't something to sneeze about when you could have just continued the proceedings for free. Like $300 ain't nothing you get you have to pay $300 for being foolish. That's not nothing just to sweep under the rug like it ain't no big deal. I mean, $300 is $300. but you had to pay $300 because you were being foolish. See, that's the key thing there. That's the key element. $300 for being foolish. So keep that in mind. Now today we are talking about, what are we talking about? We're talking about the appellate court. This is a mortgage case in the shut down. Today we're talking about an appellate court, this appellate court case regarding bankruptcy, a mortgage. Actually, we're going to watch it on YouTube, TikTok. Y'all come on the YouTube side. This is we at the New Culture Empire on YouTube. Y'all come on the YouTube side because I'm not gonna be able to double stream so y'all can see the video. But what we're going to do is we're going to listen to the appellate court. Now, let me just tell you this about the appellate court. You think that the regular court is nuances and only court rules and procedure, you must ain't step into appellate court and had to argue in front of the panel. You think that you better know your stuff in regular court. When you step into the appellate court, if you don't have a clue of the rules and procedures of the appellate court, yet alone just regular court, you are going to lose. The appellate courts does not review the record the way we think they're going to review it. The appellate court is not so much of the facts of the case. It's more about the procedural history of the court, case precedents, and the overall proceedings, the overall hearings. This is why they read the record. They read the transcripts. It's not so much about your facts and evidence anymore. It's about, was the judge within his lawful authority in ruling against you? Was the judge supposed to rule for you in this manner? Did the judge do the right thing by not letting this evidence in? Did the judge prejudice you by allowing this? That's the plain error. And if you don't raise the argument in the lower court, you waive that right to raise it on the first time, and then they're only going to hear your case de novo if they decide to hear your case. I learned that from my own case. I was this close from beating the federal government on appeal in the criminal side. I was this close from beating the federal government. I was a hair away. All of the cases that they had me in abeyance for, they ruled against those people, but they didn't rule against me because of they ruled against them. I got ruled against is because I got stuck between a rock and a hard spot. The case that came out that I relied on, it came out after I was sentenced. And the appellate court said, however, Thomas did not raise this argument in the district court. And since Thomas did not raise this particular argument in the U.S. District Court, we're not even going to entertain that portion of the argument on this appeal, even though that was the portion of the argument that I was going to win. And that was the reason why I lost my appellate case against the federal government. I was a hair away. And you know what the courts was telling me? Hey, don't wait for another case. You be the first. You be the first through the door. You set court precedents. Nope, don't wait. It was a tough pill to swallow, but I'm telling you this, it changed my outlook on being aggressive in court. Don't wait for no one. Don't wait for, if I see 5,000 people making the same claims, I'm going to deliberately structure my claim in a way that it stands out from the rest of the pack. They see these same claims coming in for the past 30, 40 years. I don't know why in Sam Hill do y'all think that they're going to rule differently from you. See, there's a difference between wishful thinking and hoping and just being delusional. There's a difference. And a lot of what I see is wishful thinking and delusions. And if you think I'm wrong, all you have to do is when I have my open panel, open debates, hit the link, prove me wrong, you bring your facts and evidence and you prove that I'm wrong. Bring your facts and evidence, and we're going to stick to the topic. We're going to stick to the topic at hand. Because no one walking the face of this earth in these spaces can prove me wrong. Half the people don't even know enough of what I talk about to prove me wrong. They have no clue. So, TikTok, I'm about to end it on this side. I'll restart it and put the device chat instead of the live screen because I don't want TikTok, you know what I like to do. And I ain't got time for all that. So I'm about to restart this live. I'm about to end this live, restart it on the device so y'all be able to hear it. And then YouTube, we're actually going to get into this appellate case. And I got a feeling it's going to be a banger. All right, TikTok. Appreciate y'all. I'm about to restart it on the device side. Woo. Hey, TikTok starting to come around a little bit, y'all. But it'll never be like the original, the New Culture Empire on YouTube. All right, so let's share this screen. And y'all shout out to here we go. Y'all and take a moment, y'all, to follow. Y'all take a moment to follow Team Fatty. Y'all take a moment to follow Ilkhan Ali. Y'all take a moment to follow Nino Nation. Y'all, I'll drop all their channels in a post. Y'all take a moment to go follow all them. It's a good break from this side of the conversation of YouTube. It's actually fun and entertainment. Red Lipstick Vibes, Diesel TV, and all the Untouchables. I will be dropping all their channels in the link. Y'all go over there and follow them too, man. Y'all may catch me live. Y'all gonna catch me live over there a lot. Okay, so this is the Appellate Court. This is out of, actually, this was September 25th last year. San Francisco, California. And this deals with complex issues related to bankruptcy and the enforceability of loan claims. A representative for the appellant articulated key arguments about whether acceleration of debt occurred under Arizona law, which could trigger the state's 6-year statute of limitations. The discussion dives into various legal precedents and how actions like demanding full repayment or filing for relief from a stay can signal that the entire balance is due. Notably, the dynamic between the opposing counsel becomes intense as they clash over interpretations of orders and the implications of a creditor's ability to pursue claims. As the arguments, they got a lot. So we're just going to read it as we go. They had a lot going on with the description.
Good morning. Mr. Hoff, would you like to reserve any time for rebuttal?
Yes, Your Honor, I'd like to reserve 5 minutes.
All right. Hopefully you can see the clock. Please begin.
Good morning, Your Honors. May it please the court. I'm Adam Hoff on behalf of the appellant.
Before we get started, these judges know the law like the back of their hand. They not playing up here. You better come correct when you're standing in front of a panel like this. They're not playing. And they will cut you off and grill you. So you better remember what your original thought was too.
This case is about the finality of court orders and their enforceability in the bankruptcy process. This appeal presents three legal issues for review. One, whether the loan was accelerated in 2009, triggering the Arizona 6-year statute of limitations. Two, whether the 2010 claim disallowance order precludes relitigation under the principles of res judicata. And three, whether the lien is void under 11 U.S.C. 506D.
Res judicata is basically the prohibition against bringing a claim into federal court in which a state court already decided its merits. So basically, just because you didn't like the ruling in state court doesn't mean you can go to federal court and have the case relitigated. It's going to be prohibited, going to be blocked. That's what he meant by that.
Because the claim was filed and disallowed. We view this as each issue void under 11 U.S.C. 506D. Because the claim was filed and disallowed. We view this as each issue independently requires reversal. Together, they show that that river flow funding has no enforceable claim. I'll address acceleration first, then res judicata, then lien avoidance. And so moving straight into the acceleration issue, under Arizona law, a debt is accelerated when the creditor takes an affirmative act clearly signaling that the entire balance is due.
Okay, so for you common law people, it's clear that Arizona law is the controlling statute here, not your federal common law jurisdiction in the UCC. Okay, so you can put that in the trash. Just dump it right in the trash and walk away. Don't even look back at it.
The Arizona Court of Complaint Services versus Madison explained that examples of acceleration include demanding full payment before all installments are due, repossessing property, or filing suit for the entire balance. The standard is an overt act that puts the debtor on notice. In this case, we have two such overt acts. First, IndyMac, who at the time held both the senior and junior liens in this case, filed a motion for relief from stay in the debtor's 2008 bankruptcy case.
And was that relief from stay as to the second?
Told you. They will cut you off mid-sentence and start grilling you. I'm telling you, you better be able to articulate it and break it down. These appellate judges are going to cut you off and start grilling you, peppering you with. You think this is something? You think that's something? The Supreme Court, you're 2 seconds in, you're gonna start getting peppered with questions by Neil Gorsuch, by Clarence Thomas, by all of them. Sotomayor, you're gonna be ping-ponging ass around the court with questions. You better know it. But for you legal beagles online, you notice how the judge cited the lawyer cited case law that was actually in the state, and then he cited the case law. He gave a quick synopsis of the case or summary, and then he applied that case to connect the dots of why it's similar to his case. That's how us professionals do things. Not citing a case from Maryland when you're sitting over there in Kentucky.
Two such overt acts. First, IndyMac, who at the time held both the senior and junior liens in this case, filed a motion for relief from stay in the debtor's 2008 bankruptcy case.
And was that relief from stay as to the second?
They filed a relief as to specifically the caption was the first, but
and the relief given was as to the first.
It was not. It was a general order.
No, the relief is based upon the ask.
Told you. I told you. What did I say? Yo, we all watching some real. Oh, hold on.
They're the first mortgage or the second mortgage.
Hold on.
The first and second mortgage.
Right, but those are two separate debts. The only reference in the second was in the calculation of equity The second?
Hold on.
Entire balance.
Hold on. I got thrown off. All right, let's go.
Takes an affirmative act clearly signaling that the entire balance is due. The Arizona Court of Appeals in Baseline Financial Services versus Madison explained that examples of acceleration include demanding full payment before all installments are due, repossessing property, or filing suit for the entire balance. The standard is an overt act that puts the debtor on notice. In this case, we have two such overt acts. First, IndyMac, who at the time, senior and junior liens in this case, filed a motion for relief from stay in the debtor's 2008 bankruptcy case.
And was that relief from stay as to the second?
They filed a relief as to, specifically the caption was the first, but
and the relief given was as to the first.
It was not. It was a general order.
No, the relief is based upon the ask.
Right there. Right there. Right there. When the judge said, no, they shook their heads. This is court. You better hope that your interpretation of the law and the order is how they interpret it. You better hope it's online with how they're seeing it. It's not about what you say. And guess what? It's not even about how you interpret the law. You can only pray that you are interpreting it the same way as them. And you won't know unless you're right there in court. This is called the nuances of court, in which you only understand through experience. You will never understand how the judge is going to rule. You never know. You never know. You never know how the judge is going to rule. You may think you have an ironclad argument and they rule different. And guess what? Guess what? This is court. This is why I never guarantee court wins. This is why I never guarantee an outcome in a court case, because I can't. You never know how the judge is going to see things. I'm telling you.
The second?
They filed a relief as to, specifically the caption was the first, but
and the relief given was as to the first.
It was not. It was a general order.
No, the relief is based upon the ask. And we'll get back to that, and I think later part of your argument. The relief was to foreclose on the first. The only reference in the second was in the calculation of equity as a whole, wasn't it?
No, in what we look at, and this is an important element of the case, is we look at the order. And so I agree that the order should reflect the ask. But if you look at the order in no uncertain terms.
But the second never moved for it.
They didn't need to move for it.
Wait,
independently.
now I'm not sure if that.
Look at the judge. I'm telling you, these appellate court judges are they know the rule to the letter of what shit means. This lawyer, look at his face. You know what that is? And it's not that the lawyer's doing a bad job. It's the classic example of judges interpret law orders differently from how we interpret them. This is why I stress we have to bury our heads in case law, case precedents. This is why I use the word the procedural history of the court, meaning when I study case law, I'm studying how does the judges consistently view cases of similar nature. What is the deciding factor why they'll rule one way for this one and rule another way for this one? What is the common denominator in any single one? That is a process within the case preparation process. But no, don't listen to me. You go file a pre-submitted, pre-typed up, pre-packaged document in your mortgage defense. You just go file that, because people run away from the things that I do, because some people already know this is out of my league.
You're rocking with the best.
Same for everybody. Only the strongest survive in this realm.
How can that be?
Primarily because IndyMac
And look at the judge in the middle. Look at the judge in the middle. Look at the judge in the middle. And look at this judge on the end.
agree that the order should reflect the ask. But if you look at the order in no uncertain terms.
But the second never moved for it.
They didn't need to move for it
Wait,
independently.
now I'm not sure if that. How can that be?
Primarily because IndyMac held both the first and second mortgage.
Right, but those are two separate debts. Acknowledge the two separate debts, treated as two second debts, right?
Well, the question would be, under the order that was granted by the court in 2008, could either the first mortgage or the second mortgage move to foreclose on the property? And so my point is the debtor shouldn't have to make that determination based on the motion. It should have to make that determination based on the order. And the order has very broad language that says vacating the stay, quote, to as to, quote, any and all stays against lien enforcement.
You can foreclose for the failure to pay one monthly payment, right? So was there
That's
a foreclosure?
That's a fact. That is 100% true what the judge said. You can miss one payment and they can foreclose on you. The reason why they don't normally do it, and like that's every day, is because when you, hold on, timestamp this. March 10th, 2:44 p.m. I'm stamping it. When you miss a payment, especially when the mortgage-backed securities are backed by the government, those 3 months payments that normally when you're 90 days past due, they are already being satisfied, meaning the payments are already being paid on your behalf. You will never know that. And the payments are coming from everybody that's in that securitized pool, all the excess interest that they're collecting from everybody in the pool. So everybody that's in that pool, every borrower has really paid way more in interest than what they're legally responsible for in order to cover in cases of default. So from an economic substance standpoint, the borrowers are covering their own default.
Where the debt was accelerated? That didn't happen though, did it?
I don't think it's necessary because that is an overt act, but our point is that the mere existence of a stay lift motion coupled with the proof of claim is the overt act necessary to trigger acceleration. They don't actually have to foreclose because the stay itself, the order, which was very broad, said that the creditor had the right to foreclose.
Okay.
And
but okay, so that's there. But what's the evidence before the trial court or before us that as part of that foreclosure, I mean, okay, yes, they could foreclose, but they could have foreclosed just on the missing of one payment. What do we have before us to say that once they got relief from stay, they really did accelerate this?
Well, we couple that, and let me answer the question this way.
It seems to me that, it's not that you're asking us to connect the dots. You're asking us to fill in a blank. I don't have that information that they did accelerate it. I don't see it in the record.
So what we're saying is that the stay lift itself is sufficient.
I think.
Coupled.
1 second. I'm going to rewind it back. My laptop died outside and I got to head back in because it died outside. But I'm going to break. Everything the judges are saying is everything that I teach. Hold on. I'm going to let it play now, but we're going to back it up in a little bit. I'm going to let it play now.
Okay.
I think you've got a number of other points that are more important here. So I subject to
go ahead.
to Mr. and Judge Corbett, and I urge you to move on, and you may actually want to jump to the 506D.
Oh, okay, Your Honor. I think that, and I think 506D, when we look at, I'll move this around then. So the 506D issue is one, there is no factual dispute that the claim was disallowed. And
What does
so,
that mean? What does disallowed mean in this context?
well, in this context, our whole argument is that the argument is that there was a claim that was filed by the secured creditor, specifically the second mortgage. The trustee objected to the claim. The second mortgage actually amended the claim, and then the trustee objected again. And the court simply issued an order that said the claim is disallowed.
Okay, so going back to our earlier discussion about the motion and the request forming the scope of the order, what was the basis for the objection?
So the basis for the objection was that they should look to the collateral for collection.
Why would
because-
they look for the collateral if they didn't have a claim?
Uh-oh.
And I actually
Oh,
don't
yeah.
think
Oh,
that-
yeah. Oh,
that it
yeah.
matters.
Oh, you collateral people? Oh, remember y'all be making those arguments? Oh, the collateral is supposed to pay. Uh-huh. Let's go back. Let's go back. We about to back it up a little bit. I'm back in my elements now. I'm back. Laptop about to die.
One payment.
Very broad.
Let's walk it
said that
down.
the creditor
Let's walk it down from here. Let's walk it down. I'm back in my zone. We about to walk it down from an appellate court level. I told y'all, you think that this is just regular arbitration, district court, county court? Man, I started out in federal court first. I started reading federal case law first because those are the hardest claims to get across. It's a lot easier in the state. The state is nowhere near difficulty from me because it's the state is where your equitable relief will come into play more. It's the state. The state will come into play more. The state law is more closer and similar to the common law that people talk about. Federal law, federal case, federal judges, it's a totally different level. And I learned that from my lawyer, Miss Tassie, who was my federal lawyer, who hit me to how the federal is different from the state. It is far more difficult to win in the federal court than it is to win in state. Far more difficult. But let's get to it.
had the right to foreclose.
Okay.
And
okay, but what? Okay, so that's there. But what's the evidence before the trial court or before us that, as part of that foreclosure? I mean, okay, yes, they could foreclose, but they could have foreclosed just on the missing of one payment. What do we have before us to say that once they got relief from state, they really did accelerate this?
Right there. So they're saying is, when they got the relief from the state, did the lender actually accelerate the mortgage yet? Because if you're arguing that the order from the relief of stay either should not have been granted or bringing a claim against the lender, if the lender did not accelerate the mortgage right after the relief of stay, then I can see what you're talking about. But the judge is saying, hell, you missed one payment even before bankruptcy. They could have took the home then. See, these are the things that you have to try to anticipate before you step in the courtroom. This is all part of court nuances. These are the nuances of court that you're not going to be prepared for unless you got experience of being inside a courtroom. I've got 22 years of experience of being inside state and federal courtrooms. I know how that nuancy one word can change a whole argument to the judges. I've seen it. I've seen it in my own case. The government did something stupid and the judge said, One thing with the appellate courts, you got 2.5 seconds to make an impression on them. And you got to be 100% through all their grilling. And then you just hope that the other side is weaker than yours. And then that's still no guarantee because they're going to apply the law at the end. This is all the legal standard of court. They're applying the legal standard to every single one of his claims right now. It has nothing to do with your arguments. It has everything to do with how does the court apply the legal standard to my claim. It doesn't look the same.
Well, we couple that, and let me answer the question this way.
It seems to me that, it's not that you're asking us to connect the dots. You're asking us to fill in a blank.
There you go. There you go. The number one thing that I see from many of these online pro se legal beagles.
You're rocking with the best.
What do I say? You got to have it from top to bottom. People was like, no, you don't. I said, you got to be 100% in your claims. You can't be off on one. This is the equivalent of produce the accounting. Show me that you own the note. They don't have to show you that they own the damn note. They have the right to enforce it. I don't have to show you I owned it. You're supposed to be showing the court that they don't, and they don't have the right to enforce. Not send me the accounting that shows that you paid me money out your own. These, I told you, these are little ankle biters. We in the NFL, these are little ankle biter claims. But y'all bringing these ankle biter plays into an NFL football field. You want to get broken the fuck up.
I don't have that information that they did accelerate it. I don't see it in the record.
So what we're saying is that the stay lift itself is sufficient.
No, that's not a good argument. You're trying to say that the stay was lifted, that's enough to presume acceleration. No. Did they accelerate or not? See, hey, I'm not just grilling pro se, I'll grill lawyers too. I'll grill a lawyer fast. He's supposed to know better.
I
When
think
coupled. Okay.
I'm saying couple. Use a new word. Stop saying couple.
I think you've got a number of other points that are more important here. Subject to
go ahead.
to Mr. Judge Corbett, and I urge you to move on. And you may actually want to jump to the.
Actually, you know what that means? You know when the judge says that, move on, you lost our argument. He might as well stick that argument in a ditch, and it better not be his principal argument. He's 100% wrong on his argument. And this is a lawyer.
The 506D.
This is when it gets good right here. 11 USC. Before we do that, let's pull up 11 USC 506D right quick so everybody can follow along and not be lost in the sauce, because this is the nuance. This is the nuance of court. And this is the stuff that they are not going to teach you online because they don't have the time, nor the patience, nor the understanding to effectively teach this stuff, because they don't have to, when all they can do is throw a prepackaged script-like document and everybody's going to be rushed to buy it. And all they got to say is, this will help you get out your mortgage. Send this in. Nobody wants to grill them on their understanding, their interpretation. What if they don't? What if they deny it? What if you got to take more actions? Nope. They always tell you, you send it, it's going to stop. You send it, it's going to stop. And then people be so desperate in their own situations, they don't even take 2 brain cells to come up with a thought that says, well, can you show me that yours was stopped when you sent this in? I mean, come on now. To the extent that a lien secures a claim against the debtor that is not an allowed secured claim, such lien is void unless such claim was disallowed only under section 502B5 or 502E of this title, or such claim is not an allowed secured claim due only to the failure of an entity to file a proof of such claim under section 501 of this title. So that is what that's saying. It's going over what lien to the secured claims which are not allowed against the debtor and void secured claims. And I'm going to tell you this, as much as I'm an animal in state and federal court. I am on God mode when it comes to bringing these claims in bankruptcy court. Oh, you best believe that. Oh,
You're rocking with the best. You're rocking with the best.
Corbett, and I urge you to move on, and you may actually want to jump to the 506D.
Oh, okay, Your Honor. I think that, and I think 506D, when we look at, I'll move this around then. So the 506D issue is one, there is no factual dispute that the claim was disallowed. And
what does that mean? What does disallowed mean in this context?
Well, in this context, our whole argument is that the argument is that there was a claim that was filed by the secured creditor, specifically the second mortgage. The trustee objected to the claim. The second mortgage actually amended the claim, and then the trustee objected again. And the court simply issued an order that said the claim is disallowed.
Okay, so going back to our earlier discussion about the motion and the request forming the scope of the order, what was the basis for the objection?
Now, here's the thing about trustee claims. The trustee's job in a bankruptcy is to recover all debt, property, assets, entitlements, whether it's agreed to or implied, or whether they're entitled in equity. And the trustee is the one who files these in-between motions to either disgorge property from an account, set off this. It's the trustee's job. The problem with today is y'all hire these lawyers to do your bankruptcies, or y'all go to these groups that's telling you to put a UCC1 claim into your bankruptcy, which has no legal basis in law of fact anyway. And these trustees are not going to present these type of claims for individuals. These claims that I talk about are presented in corporate fashions. This is why my case was so groundbreaking, because I took the whole corporate world and applied it to a consumer case, something that was unprecedented, never done before in the Fourth Circuit before I did it. So when you have someone file bankruptcy on your behalf, it's not the bankruptcy itself that they need to understand. They need to understand the in-between motions that are being filed to strike this claim down, to set off this claim over here, to get restitution from this property over here. It's the in-between motions that are filed within bankruptcy. But let me guess, they never told you that either.
So the basis for the objection was that they should look to the collateral for collection.
Why would they look for the collateral if they didn't have a claim?
Great question, Judge. Hell of a question.
I actually don't think that it matters why they.
I think it does if it's actually necessarily litigated for your preclusion. All right.
Yo, this lawyer is garbage. This lawyer is garbage as of now. Like, what are you talking about?
So Siegel, and this was even mentioned in one of the earlier arguments, Siegel basically says that whether it doesn't really matter why the claim was objected to. To your point, the trustee said they should look at collateral, but the trustee could have objected based upon the claim not being sufficiently valid. They could have objected on several grounds, but those all merge into that order.
But this is what, okay. If the trustee disallowed the claim and they didn't have a claim, whoever was representing this person in bankruptcy was supposed to immediately file that motion that in the Supreme Elite team, I know what we talking about right then and there, because court is not always about the facts or circumstances, the rules of procedure too, which they play a big part. It's also about timing. In the court rules of procedure, it's about timing. You have to time your motions correctly. Meaning,
It has to be at the right stage to bring certain claims. You bring the right claim at the wrong time, your claim is going to be dismissed. And guess what? You can't even bring it back up later. It's over with. Timing. Everybody just want to flood with documents and motions at the beginning stages. I've told plenty of clients, no, we're not filing this claim right now. We're going to catch them later down the line. We're going to walk them down slowly. Y'all be in a rush to just go attack everything and not strategically putting your plan together. This is why I do case studies. It's not, here, pay me for this. Here, get this document, go file. It's an actual modified strategic planning based on this person's facts and circumstances, which is not going to be the same when I work with this person, and it's not going to be the same with this person because everybody's cases is different. But no, go ahead and get these one-trick pony documents that they're giving to 50 different people because all 50 people have the same cases. Right.
And our point is finality in the order. If I'm looking at an order that says a claim is disallowed, other than the 506D exceptions, I should not have to look at why the order was issued. I should be able to take the order on its face and see that the claim was disallowed. And I think that's one of the issues we're looking at. And Siegel goes to that idea as well, is that we have to have finality in orders.
Bro, you are missing it. You are missing it. Who cares why it's denied? You were supposed... I'm starting to believe when the SEC lawyer said that less than 10% of the attorneys know this realm. I'm starting to believe it. Bro, you dropped me. You don't even know that you dropped the ball.
Otherwise, now we're looking at an order that on its face says the claim was disallowed. And now we're going in and arguing every single disallowed claim based upon why the motion was filed and what claims were raised or what claims weren't raised.
So, as I understand your argument is, based upon our understanding by what the trustee has submitted in, and the Chapter 7 trustee submitted in declaration, the point was that it should go deal with it outside the bankruptcy, in effect, to collect the claim. And yet, you are now saying there is no claim because it said disallowed.
Correct, Your Honor, and there is a specific remedy for that. One is the creditor did not object to the claim, to the objection to the claim.
And neither did the debtor. The debtor didn't. So you're arguing on the preclusion that's the same interest, same parties and stuff. Why isn't the debtor precluded then from objecting it? You can enforce that and say, go look, the debtor cannot participate in this Chapter 13 now because there is a prior order. Go look to your collateral. You can enforce that order, but you're asking for more. You're asking for a substantive determination that there is no debt.
Yeah. Look, am I missing something here? Is it, okay, there might be a claim against the estate, okay? In essence, it's almost be an in personam type of claim against the debtor that they could pay. But then there's also a claim against the property. There's an in rem claim here. And how is the in rem, the right to go after the property, extinguished by that order?
506D. So 506D only gives...
Key distinction. You could go after the debtor's estate, but there's also a claim against the property. That is something that's going to fly over 99% of people's heads. In a mortgage transaction, it is a claim against the property, but people take it like it's a claim against them. This is why you get these emotional filings, like they're foreclosing on them. They are enforcing the claim against the property. Your whole mindset should be from the get-go, do they have the legal right to not whatever you believe from your little packets and your pamphlets and your old Patrick Devines and Christina Wilson and all this secure party creditor Mansa. We ain't talking about from their standpoint. We talking about from a legal standpoint. Does this person have the right to enforce their security interests against their property, against this property here? Give you a better way to look at it. Some random person just walks up and says, this is my car now. And now he filed a claim against you and a random person you never met. Wouldn't you be able to show from a legal standpoint that they have no claim against your property? Would you apply the Mensa and these social media gurus terminology when you go to court and defend it, knowing that this person has no claim? What are you going to do? You're going to do it by the books. You're going to produce all the evidence. It's no different from a lender trying to do the same thing. You got to, same way you would produce if you know you're in the right, it's the same way you got to produce against the lenders. Don't try to use no alternative, secret, esoteric law to try to fight it now when you know you wouldn't fight it in the situation I just provided. You know you wouldn't fight it that way in real life. You know you wouldn't. You know you wouldn't. You know you wouldn't. Don't try to give me the no. It applies the same way.
There's two exceptions for claim disallowance orders. The primary exception I think that's valid here is that one, the claim didn't have to be filed. And I agree, in rem claims, it's long established that they pass through a bankruptcy case without a claim being filed. And so the issue here is that a claim didn't need to be filed. That's one. Two, it was a disallowed order that was isolated. So meaning it didn't say this claim is disallowed to the extent that it should be, that the property should be recovered outside of the bankruptcy case. And any such ambiguity, I don't think the objection or the order on its face was ambiguous. It just clearly said the claim was disallowed. And so when we look at 506D, 506D really only gives an exception under 506D2 due to failure to file. And so in this case, the claim was filed, the claim was disallowed. And so I don't see that there's any sort of wiggle room here arguing that the trustee, yes, the trustee said they should seek recovery outside of the case, but the trustee had several other actions that they could have brought and they didn't. And so Siegel really goes towards that finality. If no objection had been brought, the claim would have been considered a valid claim under Siegel.
Bro, that argument is weak. It's weak. You're just babbling. You're lightweight starting to babble now. It's weak. It's weak.
And then I'm unless there's a pressing question, I'll reserve the rest of my time.
Any questions? Okay, thank you. Ms. Silberstein.
Thank you, Your Honors. Good morning. Chris Silberstein on behalf of Appellate Secured Creditor Riverflow Funding. As Your Honors hone in on some of
this right here, what the name was? Riverflow Funding. When it gets into a bankruptcy court, look who showed up. Look who showed up. Look at who's in court right now on behalf of the secured creditor. Who's in court right now on behalf of the secured creditor? Who was in court? Yes, you guessed it. The special purpose vehicle is in court.
You're rocking with the best.
The special purpose vehicle is in court. If I was defending this debtor, that special purpose vehicle would have gotten stricken. Number one, from an accounting standpoint, the special purpose vehicle, you have no claim. From an ownership, UCC 9, Article 9, you have no legal claim. You have no ownership rights. And this is why in the middle of bankruptcy, I will be filing those in-between motions to strike Riverflow, right, snipe them right down out the sky. This is a classic example. And the fact that Riverflow is still in the game lets me know that their lawyer don't even know what I teach. Lets me know. Because if he knew it, Riverflow would never be in this position right now.
the issues, I think one of the key issues is that motion for relief filed in the Chapter 7 was not filed by my client's predecessor in interest. While the lender who originated both the first and second was IndyMac, IndyMac filed that motion for relief as to the first and only to the first. And we see this in the fact that the exhibits attached to the motion for relief are only applicable as to the first. And Your Honor pointed out the fact that the only reference to the second was in the equity analysis. And I think that's the other factor that points out that that motion for relief was only as to the first. And yes, the order language was very broad, and it did say that the relief was as to all stays, but then the remainder of that sentence indicated all stays under 362 and 524. It did not elaborate all stays as to other loans. As such, that motion for relief cannot be deemed an acceleration of my client's loan.
That is a hell of an argument. That is, and I just had a feeling she was going to start mopping the floor with him. That is a hell of an argument. It cannot be deemed as an acceleration from the stays. The first lawyer is trying to say because they got relief from stay that there was automatic an acceleration. When it goes back to black and white. Either they accelerated the loan or they didn't.
Another issue that we have in this case is whether or not the proof of claim that was filed in the Chapter 7 is an acceleration. It was not an acceleration. I
agree.
Appellant references a number of cases that are Chapter 11 based, which is distinguishable. And the fact that those were Chapter 11s and the relation for the acceleration is under 11 USC 1124, which is not applicable in a 7 or now in the 13 case that from which the matter is being appealed.
Court procedure, nuances. She is doing a hell of a job.
Another issue that we have is, as your honors were questioning a few moments ago, 506. The trustee did not file the objection to claim based on 506. The issue was whether or not the trustee needed to pay the claim.
Right there. Trustee already doing him a disservice. The disallowance of claim, not the disallowance, the motion to disallow the claim.
It was an effort to reduce the administrative expenses, determine what claims did or did not need to be paid.
The problem
was not a question.
Counsel, the problem is that it asked that the claim be disallowed, and the court ordered the claim was disallowed. So how do we take that order and apply it with 506D?
Well, a claim can be disallowed without invalidating the underlying lien.
And what's the authority?
Your honors mentioned
Law School 101. You never bring up a claim that you cannot substantiate in law and fact. We're not talking to sovereign citizen claims. Don't even start thinking, get the wheel spinning in your mind. Don't present no modern money mechanics. Don't present your birth certificate as claim. Don't present those sovereign citizen packets. Don't present the Cestui Que Vie Act. Don't present none of that. We're talking about factual law with case law to support it. She said that there could be a disallowance of claim without affecting the underlying lien. And he said, what's your authority? That's how judges look. Any claim that you cite, you better have authority to back it up, not your belief. Now, what most people would do in this space, let's say that they were her. They would say, oh, a disallowance of claim can, there could be a disallowance of claim without affecting the underlying lien. What most pro se legal beagles would do is they'll just go on to the next topic. They'll just go straight on to the next topic. Not substantiated, no case law to support it. They'll just move right along. And this is why you see with a lot of pro se cases, they'll file their lawsuits with zero case law to support any of their claims. There will be not one case cited.
I'm sorry?
What's the authority?
Oh, you heard him.
For a secured claim, what is the authority that the lien survives?
Johnson versus Home State. That case has held since the 1800s.
So he's writing that case down. Johnson versus Helm State. It is a old case. So he's writing that case down because they're going to research that case and see if it's applicable to her claim.
That the lien passes through to
she's writing it down too.
Survive the bankruptcy. The in personam rights are extinguished with the discharge. However, the in rem rights remain.
But that's the problem, is that the in rem is only as long as there is a lien, and 506D expressly voids the lien if it is not allowed.
That's true. That is true. That is true. I've researched. They're saying everything I researched, from the case law and bankruptcy to the statutes to top corporate professionals interpreting the bankruptcy statutes over the years and how they changed, from ex-judges putting out papers on it to lawyers from the Lawyers Association putting out publics on it, from colleges and professors putting out all their opinions on it, all the professional opinions. The judges are correct here. They are 100% true.
Because, and I guess my problem with Judge Collins's decision here is he concludes that the earlier bankruptcy order put the creditor, your predecessor in interest, in the same position as if the claim had never been the claim had never been filed. But the claim was filed. So in that, your opponent is arguing a very strict literal interpretation, but the words line up.
This is where it starts to shift. Remember when I said, you're not making a good showing, you better hope that the other side's doing poorer than you? She started off hot, and then she couldn't answer that one question to get her over the hump. Now the tables turn that fast in court. This is court. This is how court goes. This is how court goes. You start out good, you mess up, you better hope they don't pick up steam and they lose steam and they start to do worse than you. This is playing out in front of all our faces. Are you talking?
The intention is not the disallowance was not to invalidate the underlying lien. That's the key here. That wasn't even an issue that was addressed in the Chapter 7. And then with the recent default and the initiation of the foreclosure process and the subsequent Chapter 13 bankruptcy, these issues come back. I think Judge Collins was correct when he noted that even if the debtor is not personally liable because of the discharge, she still has to deal with the debt because the debt survived. And it has to be treated in the plan. Otherwise, she risks a motion for relief in the current case so that my client can proceed with foreclosure.
So how do we deal with the language of 506D, which doesn't give the exception that Judge Collins used when he made your ruling? He basically said, well, they did file a claim, but this is kind of like they didn't, and the lien just passes through. So I'm going to rule in their favor on that basis and say it satisfies the 506D2 exception. But if a literal reading of the statute you might disagree with him on that. How do we square that?
That is a hell of a question, and that is one of the nuances in court, how judges will interpret the statute on case by case. He stretched that language as far as it can go to now there's many gray areas. There's many gray areas, and guess what? Bankruptcy judges are afforded broad powers under Sorry. The broad powers. Let me show you. 105. The court may issue any order, process, or judgment that is necessary or appropriate to carry out the provisions of this title. No provision of this title providing for the raising of an issue by a party in interest shall be construed to preclude from the court sua sponte, meaning on like sua sponte, when they're on the court, taking any action or making any determination necessary or appropriate to enforce or implement court orders or rules or to prevent an abusive process. This gave the court, the bankruptcy judges, broad powers to make any rules necessary or appropriate. It's one of the broad powers of the bankruptcy court is to say, yeah, your transaction said that, but nah, the transaction really meant this. So we're going to go off with the transaction meant versus what the transaction said. That means the bankruptcy courts has powers to pierce through the contract and shut down the whole binding contract law argument. That's one of the broad powers bankruptcy courts have. So she has an issue now because although the judge stretched it and it created gray areas, it was well within his powers to do so. Now she has a uphill battle with that question.
I think,
and that's why she had to think. I see that pause. I know she's in an uphill battle. He knows she's in an uphill battle. Every judge knows she's in an uphill battle. She knows it. That's a difficult question to answer. There's really no answer to it. And I think she knows that. That's why she asked it. These judges aren't stupid. I know they want y'all to tell y'all the judges just violates rights. The judges ain't got no power. The judges can't do this. They ain't no real judges. They're all administrative agencies. They don't know shit. And you're going to find your ass up Schitt's Creek thinking these judges are highly intelligent people. They don't get to this position for nothing. Look at her. That's a tough question. That is a tough question.
I think it comes from the definition of a claim. The claim definition gets to whether or not the money is owed. And the money is owed. The lien survived the Chapter 7.
Is there, are you familiar with the Blenheim or the Lane case? Is there anything that we can draw from those cases as a basis for supporting your position?
Yes, in those cases, the facts are distinguishable from this matter. In Blenheim and Lane, you had adversaries that sought to invalidate the lien. We didn't have that in either the 7 or in the current 13. The whole purpose of those was to avoid the liens. The purpose of the trustees' actions in the 7 was to disallow the claim and narrow the administration of the estate.
Well, and in the Chapter 7 case, doesn't the trustee need an order or an amendment to the claim or something that says, I don't have to pay this one because it's a claim on the books and it's allowed until it's, it's valid, prima facie valid and allowed until somebody objects. So he had to do something, right?
I think the trustee needed to do something because the proof of claim was filed.
That lady in the middle is sharp as a tack. the judge in the middle, the lady, that is a very intelligent judge. That judge is highly qualified to be in her position. That judge, all of them are. She's the only one I looked up. She is a very highly well qualified judge. She's not asking questions that she don't already know the answer to. I'm telling you that much enough. Telling you that much. Y'all keep playing around thinking these judges are the way them sovereigns want to paint the picture. Go in there and get your head spanked to the white meat. And then you want to know why? Because they always want to sue a judge. Yeah, they never win with the judge. You sovereign citizens never win with the judge. That's why y'all want to come on TikTok rushing on a panel after you just filed to a stupid federal a lawsuit against them, which many cases they don't even respond. They don't even respond. And the judge just dismissed those claims on its own accord, sua sponte, because they're not going to allow you to make a mockery out of their colleagues with your sovereign citizen, little whining, moaning, complaining ass claims just because you decided to not pay on your mortgage and you thought that magic document was going to get it to stop. And then you got even more frustrated because now you feel like you got scammed. And now they're taking your stuff. And now you're actually mad because they're taking your house, not mad because they actually violate your rights. But you don't want to accept the fact that you actually created it all when you made the conscious decision to stop paying just because someone told you to, coupled, Mr. Couple Guy, coupled with the fact that you already wanted to stop paying on a mortgage anyway. You were just looking for a reason to justify so it makes sense in your mind. So when it all blows back up in your face, instead of taking accountability, because y'all sovereign, y'all never wrong. Everybody's wrong, but y'all always right. You never lose. Everything is just 100% when y'all say it. So instead of looking in the mirror and taking accountability and realizing, accepting the fact that you went down this sovereign citizen claim and end up getting your house taken behind it, you want to sue the judge because it's more bearable to blame someone else than the reality that you started out before the sovereign citizen with just not wanting to pay the bill, but you got bit by the sovereign citizen bug. Now you end up without the house. So that's how it really goes. But they don't want to say nothing. I'm going to tell you how it really goes. This is what they not going to tell you when you fall down these sovereign citizen beliefs. And I don't care if you say there's no such thing as a sovereign citizen. You can't be a sovereign and a citizen, or a sovereign citizen is an oxymoron, because that's what they was telling them to say to the courts and other peoples who would call them sovereign citizens back in the early 90s. So even your response is not even from your own mind. Come on.
Time after time, you see in Chapter 7s where secured creditors file a claim in an abundance of caution, and the U.S. trustee or the Chapter 7 trustee objects because they're secured and they have the in rem options, which is exactly what we have in this situation. And the whole purpose is to eliminate one of the claims from the claim register, such that the trustee doesn't have to include that in the administration of the estate. It does not go to the validity of the lien, excuse me, or whether or not that lender or servicer can pursue those obligations in rem. Other issues that I note with regard to blend time is that the basis of that objection was validity, as opposed to trying to dispose of a claim to narrow the issues that the trustee had to deal with, or the claims that the trustee had to deal with. Additionally, the court in Lane noted that the issue there was the proof of claim had been filed by a party who was not entitled to enforce the debt. So we have a little bit of a distinguishable fact there versus our current case where the predecessor in interest was entitled to enforce.
Now I see what happened. Now I see why the SPV is there instead of the original. Now I'm connecting the dots. So from what she said, from what I could piece from it, the originator of the mortgage filed the claim. The originator of the mortgage filed the original claim. When you come to bankruptcy, everybody knows they're just a servicer. They don't have any ownership rights. This is why the SPV is now, because they transfer the ownership back to them. But what's even more sinister about this, the SPV don't even have the legal right to enforce the debt. That's the trust. Why isn't the trust filing this claim but the SPV? The SPV ain't nothing but a placeholder. Get the money here, take it here, give it to the sponsor, sponsor give it to the originator, get the money from there, flows through here, it flows here, flows here, flows here, then it flows to the investors. See, you know what? Ain't nothing to keep talking about. Just keep going.
That debt, my client's entitled to enforce that debt. So the disposition of that matter was for a different purpose. And in determining whether or not that particular entity had the ability to file that claim from the outset.
Thank you.
I don't have anything further unless your honors have any additional questions.
Let me just explore a point you were making. Your predecessor did not respond in the prior bankruptcy. By that lack of response, allowing the objection to stand, one way to look at this, I think, and I'm interested in your view, gets to what Judge Corbett said, is the secured creditor was willing to forego its participation in the Chapter 7 estate and any in personam recovery, essentially on its undersecured claim, if you want to break it down to that part. Isn't that really what you're saying is the effect here?
So what happened was the original lender, started to file a secured claim, a proof of claim. When the bankruptcy was filed, I can almost guarantee that, knowing that servicers usually don't have, they see through their I'm the lender play in bankruptcy. When they filed the claim, whether it's secured or unsecured, when it came to the servicer, they put unsecured. Because it's easy to prove that your servicer is not the legal owner of the mortgage. 99% of your people who originate the mortgage with, they did nothing but to create the receivable and package it to the securitization. They have no legal ownership. That's so common, it's just a matter of common knowledge. Unless you're way low on the understanding total pole, then I probably told you something you didn't know. Especially if you claim you play around in these spaces. If you're not really in these spaces, there's no really need for you to know. Doesn't matter. It's a nothing burger.
Correct. Their intention by not opposing was to abide by what has happened since the 1800s. The debt rides through the bankruptcy and affords them the opportunity to pursue it in rem.
Right, under Homestead, they were looking solely to their in rem rights. And it really is a quasi-bifurcation between unsecured in personam Chapter 7 recovery and in rem collateral recovery. And the election was made by not objecting to recover only against the collateral, which is what you're seeking to do now. Is that a fair statement?
Correct.
Okay, thank you.
Yes, Your Honor.
Any other questions? All right, thank you. Right.
Thank you.
Trav, we've got about 4.5 minutes.
Thank you, Your Honors. I do want to then address Blenheim and Lane. I think it's important to note that 506D exists, or 502 exists, and that there is a specific exception.
Well, this claim, the original, that's an important point, isn't it? Because the original claim objection in the first bankruptcy was never 502. It was not under any basis under 502.
Well, I don't think it needs to. So
no, it does,
problem,
because that's Lane, right? I mean, that you get into Lane there. This is not a substantive objection. This is merely a pure procedural objection for the administration of the estate, the bankruptcy estate, the Chapter 7 estate, isn't it?
Yes and no. I think that the problem I have with the the inference of I'm a guy who likes to look at what's written, and so I think the court should do the same.
I do too. I like to look at what's written. But then I also like to look at how judges interpret what's written. And this is where the Supreme Court comes in. Once the Supreme Court rules that 27 USC 1505 means this, that means no other court can ever interpret what that statute means that's going to be different than what the Supreme. They get the final say on what statutes are unconstitutionally vague or unconstitutional and how the statute shall be interpreted. The only way the Supreme Court is going to step in that case if there's too much splits among the circuits, meaning the first, third, fifth circuits interpret this way. The second, fourth, seventh, eighth, ninth circuits interpret it a different way. That's when the Supreme Court would step in and give the final say on how their statutes interpreted. I mean, the Supreme Court, they take about 20 cases a year. And they're only going to take cases that are of national importance. So if you think you're going to take your case all the way to the United States Supreme Court over your one singular finance claims, you can flush that writ of certiorari down the toilet. It's never going to be granted.
What we have here is, they're right. There's case law from the 1800s that says in rem claims flow through the case if there's no claim filed. Additionally,
there's three other circuits that's also held that if it's a procedural objection, that does not affect the substantive of the claim, and therefore, if it does not fall under 502, it cannot affect the debt itself.
Well, I think that what we have, though, is we have Siegel. We have a case that essentially says if you don't object to the claim, it's a valid secured claim. And so I always look.
What does that mean for the Chapter 7? As to Judge Brand was saying, what does that mean? Okay, the trustee didn't happen. What was going to happen then? They were going to participate in the recovery, which, to your point, may have been acceleration then, correct?
Was going to bring that up, which is their claim, and I didn't mention this in my original argument, their claim requested the entire balance. It was both matured and unmatured.
Let's be fair here. The claim was saying what the debt was, right? Because the debt is defined under the bankruptcy code is any matured or unmatured obligation, correct?
Correct. And so in this hypothetical, if the court or if the estate, for whatever reason, had recovered enough funds to pay that claim in full, I think the claim would have been paid in full. I think that was one of the concerns.
Yeah. So when they file into Chapter 13, you have to pay the full amount?
Well, the claim has a secured component and unsecured components typically.
Well, no, but that's the point. It's the claim. Then there's the debt to be paid, right? And that is an evolution. That's why I'm having a hard problem with your argument that by filing a claim, you have accelerated a debt. Maybe if you seek to enforce it and recover, but you may also want to just cure the arrears, or you may just want to, as counsel said, be cautious to see what happens and then allow that objection to happen so the administration of the Chapter 7 may proceed.
So I point to two things quickly, because I'm running out of time, on the acceleration. The point that I was making is you gave several reasonable explanations as to what you can do with that proof of claim. The debtor shouldn't be expected to be a mind reader. I think that
They'd have to in Chapter 7. That wasn't the debtor's problem.
Well, the question is just whether Arizona law allows you to assume that was acceleration. I think it does. They didn't explicitly say this isn't an acceleration, and I think that's enough to get us to acceleration. But I'd like to address 506. I think I think that the argument that bifurcates this claim, the claim was filed. There's no argument it wasn't. The claim was disallowed. I don't think it matters why the claim was disallowed unless it goes to the 562 was this the proper party? No one argued that. Blenheim and Lane both go toward this proposition that Congress is fine with disallowed claims where you don't respond. In this case, they didn't respond. It's analogous. And so they sat on their hands. They didn't respond to the objection. They could have clarified in the order that the claim was disallowed as to only in rem or as to only in personam, not in rem. And so I
You ever seen those?
No, you're still, Lord, no, you're still looking at it wrong. No. We know the order does not kill the underlying debt, the underlying lien. The problem is the judge already, since they disallowed the claim, the judge, like they didn't file a claim. Why are you still, what are you not seeing with that? And you're a licensed attorney. So all this acceleration and they could have did this, you can flush that down the toilet too. I get what you're trying to do, but this is, you know what?
Orders. Have you ever seen?
I've seen a lot of those orders. Well, not that specify those two
exactly, Cap, because I was about to say Cap. That's why the judge looked at it, Cap.
things, but I absolutely see that they can. I honestly, secured claims don't file, or secured creditors don't file claims in cases like this. So I don't think they want the risk. So I think that it's an important element here. I've definitely seen orders where debtors weren't clear enough in the language, and they were harmed by not being clear in the order. And I think this is the case here. They had an opportunity to object to the order, to file a motion for reconsideration to clarify the order. None of that was done before the case was closed.
All right, thank you very much for your argument. This matter is submitted.
Oh yeah, and for you, securitization, looking for a monetary come up, social media, pro se gurus, you will never see a dime from it. Go ahead and just, you can flush that down the toilet too. I'm gonna get a toilet flush sound. I'm gonna get that too, because a lot of this claims y'all need to just flush down the toilet. Now, you will never get any type of payout for the proceeds for the securitization. Not in your FDCPA claims, not your state claims, not your civil claims. There's only one venue that's going to entertain that, and that's bankruptcy. But you might as well flush that down the toilet too, because the way y'all going to present it is going to get thrown out as frivolous anyway.
Mr. Davis or Ms. Davis? Okay.
Now we move on to the, what do they call it? We move on to hold on. This is the authenticated birth certificate. When you get that apostle by the Secretary of State, this full faith of credit. Once again, hey, somebody give me a toilet. About to flush another myth down it. Okay, so there you go. The online myth is that with the Secretary of State's apostle or stamp or that little cover sheet saying full faith of credit on it, because they have a literal meaning, a literal interpretation, they have no context. They think that the full faith of credit is analogous to some type of, oh, this debt is going to be paid through this birth certificate now. The full faith of credit, it got stamped on there. Now, how many of you got your birth certificate authenticated without ever truly understanding why you're getting authenticated? How many of you got your birth certificate authenticated just because that was the next step down the rabbit hole? That was the next thing to do. Just like get your foreigner grantor trust, like, or the over infatuation with a 98 number, even though whether it's a 98, 93, 33, just identifies the IRS district that entered the number. It didn't have no esoteric meaning. You know, like when you have your EIN number as the account number and like your social security as the route, all those esoteric meanings, which Patrick Devine told you that it's a banking number. You know, the same way y'all think that every court transaction is a banking transaction. Just like y'all look at 27 CFR part 72-11 and think that all crimes are commercial. All crimes are commercial. Not knowing that that was in the context of the alcohol, tobacco, firearms, explosives regulation, which they only deal with commercial crimes. But you take a regulation that only deals with the ATF and says every single crime on the land is commercial now. Look at this. You see, every single thing that y'all try is always a misinterpretation, no context, taken out of context. The full faith and credit on the birth certificate, that shit just means that, yes, you can accept this as a legal document for identification. When you're sending that crap to the Secretary of State, they're not thinking that you're sending it to them to charge up some monetary account associated with it. They're just basically saying, yes, this is an official document. This could be accepted as a form of identification. This is the real person in this document. This is not a fraudulent birth certificate. You can take our word that this is a real document. That's all it meant. But in your minds, that meant that now you go file this on the UCC1. Then when it's time to discharge your debt, you go file a UCC3. You first started off with a fixture filings and all that. But as soon as Gene Keating said you got to make it an agricultural lien, now everybody goes to file themselves like they're a fucking cow in the middle of a ranch somewhere. And then you check that transmitting utility, which only applies to electric companies, railroads, pipelines, like those. But no, since they say the transmitting utility, that's your all caps, everybody checks that box. When it means nothing. And for the love of Jesus H. Christ, spelling your name in all caps as the debtor and spelling your name in upper and lowercase as secured party creditor means nothing. It's still you. So when y'all say you can't be a sovereign and a citizen, I say you can't be a debtor and a secured party, because that's all what you're communicating to the office when you file your UCC1. Toilet, it goes.
I'm the beneficiary of Dwayne Davis right here. The beneficiary.
I'm taking everything that you love. I'm taking every process that you believe in wholeheartedly. I'm taking everything that you are emotionally charged up about, and I'm crumbling it right in front of your face. Taking your whole identity and I'm crumbling it. Now what do you have?
What is it?
Are you Dwayne? Excuse me. Are you Dwayne Davis Jr.?
I'm the beneficiary owner right here.
Do you reside at 2170 East Jefferson, Unit 1007?
Yes, the estate does assign there.
I'm not gonna get on the FCRA. I didn't cover that. I knew we ain't even gonna talk about that. Now everybody's so worried about the Fair Credit Reporting Act when you're in debt. You ain't mind about how they was reporting it when you got the line of credit. Now that your ass swimming in debt up to your hair follicles, now you want to worry. Now you want to worry about how they're reporting the debt now. All of a sudden, just out the blue. When you got that line of credit, you ain't care. When you got that mortgage, you wasn't complaining the very next day about how they reported it. When you got the auto, your ass didn't give a damn then. Don't give a damn now. Don't give a damn now. The things that they will do to get out of a debt is mind-boggling.
Do you reside in that property?
The beneficiary, yes.
Do you? Who the person I'm talking to, is that the person who is in this property at 2170 East Jefferson?
Now look at this idiot. Look at this idiot. Look at this idiot. He's holding up the Secretary of State talking about the beneficiary lives there. Beneficiary of what? Of what? Nope, there's no estate in your name based on the birth certificate. There's no secret account with it based on Social Security card. There's nothing there. No estate, no trust, no nothing. So what are you the beneficiary of? Nothing but a piece of fucking paper. No legal validity. Nothing. You're not the beneficiary of it. It doesn't exist.
You're not answering my question.
I don't fully understand it. Say it again.
All right.
I know you don't. They never understand. Normal, regular speaking English, they now don't understand what normal English words mean. I told you, it's like you got it's like, but when you follow these beliefs, it's like they have to extract your brain, open your skull, shake all your brain cells out, shake all your cognitive reasoning, take the frontal lobe, take your pineal gland, replace that out with the redemption manual. That's what it seems like they do. Like these people are on autopilot. The lights are on, but nobody is never home.
Hey, what's going on, guys?
You can shut up too.
Welcome back to your favorite YouTube channel, Two Arguments. Let's go ahead and roll that footage.
Calling case number, thank you. Calling case number 22393437. This is Pasadena Investments LLC versus Dwayne Davis Jr. and all occupants at 2170 East Jefferson, Unit 1007.
And this idiot is holding that up like it's supposed to mean something. Like his ass is still not going to get put out. Like the way they think that people are going to be moved by their document submission is funny. They really think that they spend about $500 a month at the post office submitting these frivolous claims, and it's going straight in the shredder. And then we're not going to talk about the ones that are so cheap that you put a statue on your envelope just so you don't have to pay the stamp. Like they don't even want to pay the money it costs to get a stamp. All for the post office to return the sender with that arrow in the stamp box. Not enough postage stamped. Now tell me, how many of your sovereign citizens ever went through that? Oh, man.
Your Honor, for the record, Attorney Frederick J. Coleman, P. 56548 on behalf of the plaintiff. Your Honor, Mr. Davis at this time owes $6,706, court cost of $157. This is a subsequent hearing.
All right. Mr. Davis or Ms. Davis? Okay,
Yeah, I'm the beneficiary of Dwayne Davis right here.
There you go.
Beneficiary.
There you go. Already.
What is it?
Are you Dwayne? Excuse me. Are you Dwayne Davis Jr.?
I'm the beneficiary owner right here.
Do you reside at 2170 East Jefferson, Unit 1007?
Yes, the estate does assign there.
The estate does reside there. The estate resides there. So what did they do? Did they uproot the estate from sovereign citizen land and just park it in the unit? How does that work?
Do you reside in that property?
The beneficiary, yes.
Do you? Who the person I'm talking to, is that the person who is in this property at 2170 East Jefferson? You're not answering my question.
I don't fully understand it. Say it again.
Of course, Your Honor. They're not going to answer the question because if they answer the question in a simple, logical way, it's going to refute everything that's in the script that they're reading off camera. So they got to say the go-to response, I don't understand now. When my 4-year-old can understand what's going on. Now I don't understand. You know what that means? I don't want to answer that question because if I do, my whole script is invalidated and I haven't even got past the first 10 lines on it.
All right, okay. At this point, I don't see anyone who resides at 2170 East Jefferson, Unit 1007. If you
I told y'all 5 months ago, the courts, if you don't show up in your regular, normal, legal name, I don't care if it's in all caps, I don't care if it's italicized, I don't care if it's in a stencil, I don't give a damn if it's written in crown. All caps, lowercase, it's you. Cause your asses don't ever turn that goddamn card back in because it's not spelled in all upper and lowercase. You don't return that. You don't return that credit card back in though, do you? You spend the credit card though as the all caps. You don't turn it back in and say, nah, this not me. So I want to hear that crap now. And the judges are basically saying, if you are not in court, not the beneficiary, not the executor, not the estate, if you're not in court, they're either going to issue a bench warrant for their arrest or they're going to award the other party the claim on default judgment because the other party, the so-called beneficiary, has not shown up. That's what they're doing now. Now you're stuck between a rock and a hard spot. Now watch him give word salad to try to wiggle out of it.
If you do reside there, please make the court aware of it.
Okay.
Your Honor, since the defendant has not identified himself as the defendant in this particular matter.
I just did. I just told you I'm the beneficiary
Your Honor,
of the name.
Your Honor, since the defendant has not identified himself as a person in this property, he's attempting to try to act like he's a sovereign. This property is owned and is an apartment building. We're asking for a default judgment at this time. If he decides to pay it, that's great. If not, we'll be moving forward after time expires.
Well, told you. Told you.
You're rocking with the best.
Told you. I told you.
You're rocking with the best.
I told you. I am undefeated with these people. I know everything they're going to do and say before they do it.
Before we proceed with this matter, can I ask the director of the beneficiary? I'm talking to the plaintiff, sir. My legal person, I'm showing you right here, a corporation. Can you write me in 21 days and provide me evidence that you have legal?
Your Honor, none of that is required by law in this court. I'm asking for a default judgment this time. Quit wasting the court's time. If he wants to file the appropriate court paper or identify himself to the court as you've requested on numerous occasions, then we can proceed forward. At this time, playing these legal games is against.
I have the birth certificate right here.
The law.
You got the birth certificate. Okay. Are you going to get your shots? Where you going? You about to go get a passport? What you need that in court for? Oh, y'all, how could I forget? The whole birth certificate method. Let me scroll back at my sovereign citizen Rolodex. That's about from the year 1998. They was trying that. The birth certificate from 1998 to 2004. That's what we're trying. The whole create a trust with the court and go to court under the beneficiary because the all caps is a trust. That started in about 1993, 1994, and they did away with it in 2000 because no court, state, federal, local, municipal was honoring it. So at bare minimum, you're about 28 years outdated in your process right now. You're almost at a 30 piece. That's how old what you're doing is. But no, they all think it's something new they discovered last week from reading their confirmation bias online websites that's telling you can do it.
2, we provide the court with a lease agreement. We provide the court with the ledger. We're asking for a default judgment.
And you holding up that stupid apostille means nothing. You didn't pay your rent, and you're only doing this as a tactic to get out of it. That's all that matters. You can hold that apostle up. You can bring your 500 pages of frivolous nonsense that should be used for nothing more than putting in a talkie stick and putting that oil on it and burning it. That's all it's good for. To get the fire started. Get some gas lighter fluid and take your sovereign citizen documents and drop it right on there in the fire pit and spark a match. because that is what its true value is. Just enough to get the fire started, get the fire going. That's all. That's how much worth it has.
The court is in receipt of a summons, a complaint, a demand for non-payment of rent, as well as a lease agreement.
The summons was
signed
never
with-
notarized.
No. Don't try to bring a legal claim now. You abandoned the sovereign citizen script that fast? No, don't try to jump to legal. The summons were never notarized. Nah, don't try to bring no summons up. Stick to your sovereign citizen script.
Signed with Dwayne Davis Jr., as well as the proof of service. Mr. Davis, Dwayne Davis Jr., how much is your monthly rent?
I want to say 900.
When's the last time you paid rent?
900, bro. 900. You're pulling this from 900. Bro, you're not even paying $24.50. 900, bro. Bro, 900 fucking dollars. And you're pulling, oh my God. Told you these people be effed up in the game. They be effed up in the game. Because you notice, anyone, and I'm not saying you have to be rich, but anyone who is just self-sufficient, who's able just to maintain their stuff, you notice that you don't really see these people following this. You don't really see people following. You always see people follow this. It's always like it becomes a phenomenon in times of financial stress, financial strains. And with the 2008 recession, it really spread like wildfire. You only see this from a certain subset of people.
Long time. Siri paid my back balance, but Pasadena never put it to my account. So I consider Pasadena either took the money or what. I don't know what they did with it, but Siri definitely paid it. It's on the record. It's on my the record with the Siri. You can find it in their profile. But they're supposed to pay my back balance.
I can't find it in my profile. So you qualify. Sarah paid. How much did Sarah pay?
They paid up to like September, but they didn't pay they're supposed to pay July, August, September, but Pasadena never put that to my account.
Your Honor, if it wasn't applied, my client didn't receive it. That is not our burden. It's his burden.
But that's in documents though that they were supposed to pay. I have it in documents.
Your Honor, I'm not going to sit and argue all day, Your Honor. Bottom line is, the money is for his benefit. It is not for my client's benefit. Just like paying a mortgage payment. If I send a mortgage payment in, if it's not received, it's still on me. If you send a mortgage payment on my behalf and it's not received, it's still on the person who has the mortgage.
That's a fact. And that's just being a responsible adult. That's a fact. That's a fact. That's a fact.
He's the renter. It is his responsibility to have the money paid, or to whoever's paying on his behalf, that we receive it. We have done everything we're supposed to do. The documentation speaks for itself. At this time, again, I'm requesting for either default judgment or judgment by hearing.
And then I'm talking to the plaintiff. Can you just write me and saying that you have authority as a public servant to me?
Your Honor, I am not writing. I'm not sending.
Mr. Davis. This is a landlord-tenant court. This is summary proceedings. This is the second hearing, and you're afforded legal counsel. Legal counsel was available. They said that they could not assist you at this matter. Are you even identifying yourself as Dwayne Davis Jr.?
No, I'm the beneficiary of that name.
So are you not Dwayne Davis Jr.?
No, I am not. I am not.
Okay, we are entering, the court has not received the call or answer.
Now, why did he not just say, no, I'm him now? Why did he stick to it? Want to know why? Because he knows that he has nothing to lose. Either way, if he admits to it, it's still going to be an eviction against him. If he doesn't admit, it's still going to be an eviction. This is when sovereign citizens, this is when you could tell you're dealing with a sovereign citizen. Their courtroom decorum, their mannerisms, when nothing is going their way, the real them comes out. Now he's being defined on purpose because in his mind, there's nothing to lose now.
From Dwayne Davis Jr. Does anyone on this Zoom reside at 2170 East Jefferson, number 1007? Is anyone present who lives in that property on this Zoom?
Your Honor, again, no one's responded, asking for my default judgment. We can submit to the court before the end of the day, along with the full lesson.
Just playing games.
Default judgment granted.
Thank
Just
you,
playing games. Just playing games.
Please submit the paperwork.
Playing
Well,
games.
you're free to leave. Well, nobody identified themselves, so
Now, we have it looks like this is hold on. I don't want to play it. I want to play it. This looks like a lawyer. I believe. Robert Barksdale. Let me look him up right quick. Robert Barksdale. Let me see if he's a lawyer. What is he? Robert Barksdale is a real estate. He is a real estate agent. And let me make sure this is him. Does that look like him, y'all? It looks like him. He's a real estate agent. Okay. I don't really know who he is, but let's watch how he talks about mortgage defense cases on mortgage defense. Let's hear him talk and let's just see. Let's just see. Now, given the fact that he's a real estate agent, I will not apply the pro se sovereign citizen standard to him. Now I'm going to shift into legal mode, professional mode. And that's how I'm going to analyze him. If we can only get.
Give everybody a couple minutes to log on.
No need. Let's just get to it.
On my end, so whatever you're doing.
I have an appointment this week. When did you first talk to that gentleman?
Well, hold on.
Happy Monday, everybody.
Y'all, Danielle's a cutie patootie, ain't she? Grothal. She's a cutie patootie, ain't she? I see you, girl. I see.
So you have an appointment this week. When did you first talk to that gentleman? And where are
y'all? Do y'all think I should have one big Zoom meeting? Because I want to, but I feel like I'm going to be dealing with a bunch of soft sits. But I think I think we're gonna have one crash out party. I'm gonna do it, probably do it some Saturday. You know, we're gonna do it Saturday night. We're gonna have a Zoom meeting Saturday night, and I'm gonna live stream the Zoom on YouTube. I'm inviting any and everyone for the crash out party. If you interested on TikTok to join the crash out party, you send me a DM with your email. Just put crash out party. YouTube, you either can watch it live on YouTube or you can send me an email at thomaslegacy603@gmail.com, and we're going to have a crash out party. I'm going to invite everybody there, everyone with opposing views, or if you think similar, we're going to have one. We all going to crash out, a crash out party. You know what? Let's do it. Let's do it.
Are we with his appointment?
So originally, I talked to this guy about 5 months ago.
Okay.
And this is just one of those things. When I first contacted him, it was one of those like, "Hey, I'm not interested. We got everything under control. You know, we're already talking to people. Blah blah blah." That's the same rejections that
What
we
city
know.
is that house in?
This is in Ontario.
Okay, got it.
So every like a couple months, like every other month, I would drop by and saying, "Hey, how are we still going? We're still doing good." He's like, "Oh, I'm still taking care of it. Still taking care of it." It was about a week ago was the last time I contacted him and I talked to him. I left him a flyer and I said, hey, I know we've been talking. I know we
Or no?
no, not to my knowledge, no.
Okay, very good. So we can definitely do
Mortgage. He wants to combine everything into a new payment.
perfect.
Like
So
he's
he's
just
willing
tired
to
of
do a
doing
loan.
everything.
Okay.
Yeah, he's willing to do a loan.
And does he have a lawsuit against the lender right now or no?
No, not to my knowledge, no.
Okay, very good. So we can definitely do a loan to help him out. So that would be great. Okay, and we're trying to set that up for Wednesday.
Hold on, y'all? I don't know if he's dealing with mortgage defense.
I think we're trying to do Wednesday morning, 10 or 11.
Yes.
Okay, that.
She was in foreclosure. I think she's a business owner. Business slowed down. And she's probably really going to want to refinance now that the docs are probably going to be closing.
There you go, right there. Refinance. There you go with that refinance. Y'all, Supreme Elite Team University, not this week, but next week, I should have the special guest. Y'all know that's the IT specialist from Ginnie Mae, Freddie Mac, Fannie Mae. They're the one that processed the payments to the investors. So for the Supreme Elite Team University, you are going to get inside look on foreclosures and what does it mean from an internal standpoint when the decision to foreclose is made. You're also going to understand in the group in that class, what does it mean from an accounting standpoint when a decision to foreclose is being made, and from an investor, regulator, and of course, that's going to lead into when we get to the court series of Supreme Elite Team University. Court series will be the final series because it's tying everything else that we talk about into multiple court claims. I'm not just going to produce one claim. I'm going to produce multiple claims because I know that everybody is not going to have the same situation. So I prepared claims approved by top professionals. Actually, a lot of claims have come directly from the top professionals and implemented in a way that presents a consumer claims, because I'm going to tell you this, and I'm probably going to tell you many times that when it comes to pro se litigation from a consumer standpoint, Supreme Elite Team has revolutionized the litigation from pro se litigants. We are sparking a new movement that fellow pro se litigants can follow our blueprint so you can have appropriate, properly structured claims, and not only since a consumer claim, but most your complaints, you will be reading, it will be reading like a top level securities class action lawsuit from a professional level. You'll learn timing, drafting of motions, how to respond, what claims to assert, how to argue your motion in court. Instead of when they say, let's hear your arguments, you stand up with your 40-page motion and proceed to read the motion into the record when they already read it. This is what the set you is going to give you.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby. Folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
That is my guarantee. Now, I can guarantee that. I guarantee you, and let's just say you in the case of you being sued. Let's just say something, it just falls like that. I guarantee you that when you respond from the understanding from the Supreme Elite Team University, I guarantee you that the finance company or the debt buyer will not immediately move for summary judgment on the pleadings. I guarantee you the way we respond is going to civil pretrial off the break. You're going to know timing. You're actually going to know how to be in the position where you file your own motion for summary judgment, just like I've done with 2 clients.
this year. We're moving for summary judgment as the consumer. Yeah, no, I don't like that term, but you get what I'm saying. When it comes to pro se litigation, the supreme elite team is, and I say is, the supreme elite team is the standard.
You're rocking with the best.
Oh, and by the way, FDCPA claims are like 0.001% of our arguments. As a matter of fact, if I do raise it, it'll just be, hey, by the way, FDCPA, TILA, all these consumer law, legal beagle gurus, those represent 0.01% of our claims. As a matter of fact, me personally, I don't even raise them. When you defend against claims from Supreme Elite Team University, they're going to have to get an attorney that specializes in insurance, securities law, class action lawsuits, of course, consumer law, corporate finance. See, they're going to have to specialize in an array of claims because credit acceptance, I'm in Virginia. Credit acceptance had to go to Maryland to find an attorney because they couldn't find an attorney suitable in Virginia, suitable enough to address my claims. They had to go to Maryland and find a lawyer that actually won a statewide award last year and sits on the board at his practice. That's who they had to go get against me.
But whatever. But she's I remember talking to her. It was just similar to everybody else. She was in foreclosure. She was in default. Oh, she was waiting on a loan modification. And she said, yeah, please send me over your contact information just in case.
The fact that you are a loan modification. Now, I'm not mad at that because everybody is not going to know this. So I can't hold them accountable for what they don't know. That would be unfair. As a fact, I'd rather see people go take that measure than try to go ask to produce the wet ink signature, even though they're all in electronic form now. The electronic copy. Even the Federal Reserve doesn't accept original wet ink signatures. They want electronic form. The electronic copy is the standard. It's called the authoritative copy. That's why when you get your contract, electronic copy, there is no wet ink, original ink note anymore. Another thing, that bifurcation crap that you fraud stoppers, that online group kept trying to swindle people out of money to make those arguments are foreclosed. The mortgage follows the note. If the note is sold, the mortgage automatically follows it. So that bifurcation argument is now foreclosed. Somebody give me a trash can. I got another myth to stick in it. The mortgage follows the note. Facts. You know what? Once again, I hate to do this, but I love to do it at the same time. Because believe it or not, I am saving people a lot of money from going down these rabbit holes. Now, you don't have to agree with everything I'm saying. You don't have to agree with everything I'm saying. But I'm telling you this. In many cases, the mortgage is going to follow the note. We've actually read that. We've read that in my master netting class that I had as the prequel to the Supreme Elite Team University. Now, does the mortgage follow the note? Yes, as a general legal principle in the United States, the mortgage follows the note. From the American Bar Association, it's a legal principle. Once again, it's all a matter of general common knowledge. It's one of those things where it's like, you didn't know that already type things to those people. The mortgage note can be sold to a trust. The mortgage note can be sold to Fannie Mae, Freddie Mac. 1 out of every 3 mortgages going slam to Freddie Mac and Ginnie Mae and them. And that's what makes the transaction more complex when the government is involved. But it's not too much where we can't overcome it. The mortgage most definitely is going to end up in a trust. And some people, well, why are you saying that out loud? Because once again, there's court cases I have where the trust is suing the borrower. I got like 70, 80 court cases where the trust is, it's not a secret. It's a matter of, once again, general common knowledge. In their world, it's like, you ain't already know that? In our world, is like, we still figuring out the pieces. Once again, I don't operate with a consumer mindset. I operate from a corporate finance mindset. So yes, the note is always going to end up in a securitization vehicle. And want to know why? It's because you wouldn't even be able to get financing if they did it. If this is a good learning lesson. If you want 100% proof that the note is being transferred into the trust, all you got to do is just look at your pre-approval letter. That indicates that your note, your mortgage, your loan was accepted by the trust. That's just look at it like that. Because if it wasn't, you wouldn't be getting a loan. Remember when I said, y'all, there's 5 lenses to a contract? Remember I said that the 5 lenses? Remember I said the 5 lenses? I talked out loud, and then in Supreme Elite Team University, we went over the 5 lenses of the contract. See, this is why I know this thing, because now I'm looking at the investor side of the contract. I'm looking at the investor side. This is why the minimum credit score is 620. Why do you think the credit score is 620 minimum? Because in some cases, 580. If you're going through the government, it's like 560, 580. Why? It's because when they got the minimum credit score, and this is a freebie I'm giving you. So let's mark it in time. March 10th, 4:25 p.m. 2026. If you hear another guru regurgitating, because I had over 600 cloud watchers watching from the clouds yesterday. I had over 600 cloud watchers, meaning the actual people that tuned in. It says 8. I think it says StreamYard is always slow. It says 8 right here. The actual people tuned in. It says 7 right here. But when I look at the analytics, it was like 700 people. That means they're watching from the outside and not clicking in. Just like on TikTok, they're not clicking in and joining live. They're watching it on the outside where it still says watch live, click the button. They're all watching me right now from the outside. Hoping I drop something that they can go repackage and add to their repertoire in their group. Because let's not forget, whether they want to admit it or not, I am your teacher's teacher.
You're rocking with the best.
Now, the investors want mortgages between that 580 and 620, 650 range. Is because it's more interest they'll be able to get. It's more profitable for them for these mortgages. And the mere fact that it's more risk associated with a 520, 620 credit score, This is why the interest rates get jacked up on the borrower. See, with autos, it's easy to pick apart the illegal interest rates. With mortgages, it's a little more complex because they hide the true cost of credit in something termed the effective interest rate. That's what they hide it in. So what I do is I go back and bust down their books. I bust down all of their internal documents, and then I extract the real number, the real interest that they will be paying in any given year and over the course of 30 years. And the common denominator is many people with mortgages, although it says 7%, 8%, it really turns out to be 25, 27%. Because ask yourself, how can you get a loan for $300,000, but you got to pay $950,000 back? But that's only 8% interest. So what I do is I know what they're, once again, it's going back to the 5 lenses of the contract, the 5 lenses. What they're supposed to do from a regulatory standpoint, that's what I know. Then the corporate finance lens, what they actually do, how they operate. Okay, so now I got what they're supposed to be doing and what they are doing. So now you got the regulatory agencies, and you got the corporate finance. Then from the investor side, how's the investor see this contract? What's their pay? How do they do it? How do they invest in these? So now I got the regulators, I got the corporate finance, now I got the investor side. And then I take all of these, and then now I apply the legal standard to it. Okay, so how do the courts look at this? Now I understand how the courts look at it. Now I got the regulatory side, I got the corporate finance side, I got the investor side, and I got the court's legal standard side. Then I put together the consumer claim. In that order.
You're rocking with the best.
That's how I do it. And this is going to make the Supreme Elite Team University and the Supreme Elite Team litigation model and the Supreme Elite Team app the most revolutionary creation when it comes to consumer litigation. And I use that word lightly, consumer, because even though we're titled consumers, there's no difference between the Supreme Elite Team's arguments and a class action lawsuit's arguments. There's no difference between the claims we represented and the person that works at the SEC bragging. They're identical. And what the lawyers who reached out to me praised me on is guys for world, but all of them were dumbfounded on how I tied their world and brought it back to our world. See, I didn't take our world, consumer world, and try to throw it over there in their world. I stepped into their world, gathered all the intelligence, and then I brought their world back to us. And this is why we have a mortgage plaintiff running for the hills right now. This is why we have a mortgage plaintiff begging the court to allow them to be taken off the case. And we're talking about a multi-billion-dollar mortgage company. This is why we have an auto company, one of the largest auto finance companies in the world, settling with me as soon as the lawyer made the appearance. It wasn't because I argued it from a consumer mindset. I tell you that much. It's because I think like them. I read their stuff like them. I know how they're structuring it like them. I know how they think. I know how they operate. I know how their internal models work. Hell, I even know the money that they're hiding off the books. Hell, I even know what actually consists of the finance charge, and what actually consists of a finance charge is never listed on any auto or mortgage contract in America right now. Your Honor, they said this is what they disclose as the finance charge. But in reality, the finance charge consists of this. It consists of this. It consists of this. It consists of this. And it consists of this. None of that was disclosed on TV. So, once again, the 5 lenses of the contract. By me understanding how corporate finance works. Now, my TILA consumer claims are going to look totally different. My breakdown of their internal models is going to be a part of a consumer claim. You never see that anywhere else.
You're rocking with the best.
No one in the history has ever argued my case the way I did. No one. No consumer ever. Not even remotely close. Never. And this is groundbreaking, because when we unveiled the app, and for all my early investors, y'all did a good job. Y'all did a hell of a job of getting in on this, because they're going to buy us out. When you have the Supreme Elite Team litigation model right at your fingertips, when all you got to do is upload your contract and it spits out the claims as we would raise, the SEC attorney would raise in minutes, they're going to buy us out. And when they buy us out, they are buying us out for a pretty penny. And when they buy us out, all they're going to do is destroy the app. The Supreme Elite Team University, the litigation model, is going to revolutionize how consumers litigate their finance lawsuits. It's to the point now, you will never have to wait to get sued to defend. You will be right to bring these claims while you're current. Now you're in a position of leverage and power. Just like me, I brought my lawsuit while I was current. I didn't wait to get sued and then, all right, we're going to set a trap for them. I mean, I can just effectively do that. Every one of my clients, they're the defendants. You still ain't seen no summary judgment yet. The cases are still moving. But now the revolutionary part is you won't have to wait to be sued to defend. You'll be the one who's suing while you're current. Meaning your claims are being documented and the paper trail starts from day one. That is more of the reason why you
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
people to make this argument that we cannot prove in court. See, that's the difference. We don't do these fly-by-night claims. Or what's the most popular thing to do now? When everybody was doing that W sandwich, I was going to over on the other side, understanding the regulations. When everybody was doing the 1099A, guess what I was doing? I was reading the regulations. When everybody do the 1099A, do the B, then the OID, them 1099Bs been quiet, haven't they? Them 1099Bs been quiet, haven't they? One second, y'all. Them 1099Bs been quiet. I know they have. I know the 5 people that sent me a DM. I guess I must have struck a nerve. I guess I must have struck a nerve with them when they got those checks from like 2021, 2022 from the IRS, and we was in the middle of a pandemic, and the IRS was just giving everybody the benefit of the doubt, not necessarily meaning they agree with their position, right? Remember that? We know what actually took place. We know they got reversed. They were so quick to send me their checks, but now all I asked was, hey, that's cool. Can you send me the transcript? Now, I'm not asking to see all your personal information. All I need to see is just the last entry. Because, you know, the IRS accounts, they work by year. Once 23 accounts close, there's no more entries on that account unless there's a minute return. It goes to 24, then so forth. So if you got that check in 2023, the last entry for 2023 shall be refund issued. The last entry should be refund issued. And it should either be a manual refund, which is, I think, is an 840 or 841, or it should be a computer-generated refund, 846. See, a lot of people got so hyped up on these 846 refunds. That's only because the computer generated the refunds. The computer generates it. It's not like it went up to examinations and the examinations approved it. Well, you had, you know, it's a computer generated refund. So for all those people that was following Vincent Edwards and you sent me the screenshot of your check, but when I asked you, let me see the transcript, crickets. That should be the last entry. The amount of the check should match the transcript. None of them sent the transcripts because I know it got reversed. Because the way that he was doing it, I actually got the video of the lady that taught the class, and he was a student in there because soon after he left the class, and this is one of his things, he'll come to your groups, pose as a student, and then go take whatever you're teaching and then go sell it. That's why he'll ask 5,000 questions. He'll ask about 5,000 questions. And this is when you started to see Mr. Edwards using 2 1099Bs. See, he got that from that girl's class, in which I got the video on. I got the whole video, 100% garbage. As a matter of fact, I'm going to do a live review of that video when I get some time. And this is where he got the 1090 to 2 1099Bs. But the thing about that is the withholding. In a 1099B, there's rarely, if ever, any withholding. And the only time there's a withholding on a 1099B is when you're dealing with the backup withholding. When you're dealing with the backup withholding, that's the only time you will see withholding on a 1099B. Now, what does backup withholding mean? And this is all in the instructions. This is all in the regulations. See, many people will never read the tax laws because the tax laws are some of the most complex, hard to understand. So they rather take someone's advice on it because it's easier. All you do is just fill in the blanks and follow. See, that's easy. See, that's the mindset. And they'll put the withholding in knowing that on a 1099B, You rarely ever see withholding. That's the number one red flag. Now, so when you see the with large withholdings on a 1099-B, it's already a red flag to the IRS, because people that use that form correctly, there's never, ever, ever, ever any large withholdings on a 1099-B. So that's your first mistake when you're sending into the IRS. And then the second thing that they'll do is hey, y'all, let me pull the cloak off these gurus for a second. This is what they were doing to bypass the IRS's internal checks before they tightened up the system around the end of 2023. Just like people that was getting refunds for those self-created checks that they were sending to the IRS. You notice how they stopped in 2023? You know, it's been quiet 2024, 2025. It was real quiet last year. I know. See, when you know somebody whose family member works for accounts management, you'll be surprised of a little intel that you can gather. But no made up. No made up. Matter of fact, think I'm lying. You think I don't know? You think I don't know? Give me 1 second. Give me 1 second. You think I don't know? You think I don't know? Let me see if I can do it like this. Let's see. He's not answering right now. Dabu. Homie. Oh. He's not answering right now. But I'll get him on the phone. You know me. It's like I ain't lying. Is it normal to see large withholdings, 1099-B? No, it is not normal to see large withholdings on a Form 1099-B. Stop right there. Everybody just stop right there. Stop right there. What does your 1099-B say? What's in your withholding box? If it's the amount of any of your deposits, is the amount of any of your proceeds, if the amount is any of that, go ahead and take it away. Not anymore. Let's just stop there. Typically, taxes are not automatically withheld from investment sales. Instead, investors are responsible for paying capital gains taxes when they file their annual tax returns. Royce Investment Partners. If you see a significant amount in box 4, it usually indicates one of the following specific situations. Backup withholdings. Like I said, the most common reason for withholding on a 1099-B is backup withholding, which the IRS mandates if certain requirements are not met. The standard backup withholding rate is currently 24%. It's directly from the IRS. Missing or incorrect tax identification number. You fail to provide a correct tax ID number, usually your social security number, to your broker. That's when the backup withholding is. So 24% of the proceeds will be taken and sent to the IRS. IRS notification has notified your broker to begin backup withholding because you previously underreported interest or dividend income on your tax returns. Lack of certification. You did not certify on W-9 that you are exempt from backup withholding. Another instance is foreign status. Now, since all y'all foreign to the United States, won't you tell the IRS you got foreign status? I bet you they won't go for it. I bet you they're going to look at your social security number and be like, if you don't get out of here. Now, there you go. So, now, hold on. Can you file a tax return from a QSIP number attached to your your court case, mortgage, auto loans, or any other consumer finance transaction. And all this I've already researched, so we can go here because I've already researched it. Actually, I've been on the phone with QSIPs Globals twice. It's on my TikTok. Y'all just scroll down. I've been on the phone with QSIPs Globals twice. No, you cannot file a tax return using a QSIP number from a court case, mortgage, or auto loan to access funds or discharge a debt. Hey, somebody find me a toilet. We got another one coming in the shitter. We got another one. While QSIP numbers are real identifiers, using them in this way is a central component of a well-known financial scam, often referred to as the straw man or redemption theory. Damn, gurus. So y'all mean to tell me he was charging $1,000 for execution class just to show you how to fraudulently file tax returns? Told you. These gurus, only thing they teach you is how to be financially irresponsible, commit fraud, claim credits you're not entitled to, avoid accountability. There is nothing good about the teaching in these spaces. It's all negative. Definition of a QSIP. A QSIP, also known as a Committee on Uniform Securities Identification Procedures, is a 9-character alphanumeric code used solely to identify publicly traded securities, such as stocks, bonds, and mutual funds, just like the lady from QSIPs Global told me. Stocks, bonds, and mutual funds, not a security associated with your court case. As a matter of fact, there is no security that is deposited against or issued against your court case. It's a, y'all know when that theory started? That theory started in the early 90s. That's an old thing. So when I see people doing it today, I'm like, oh yeah, they don't study the origins of the things that they believe in. They think it's something that just popped up and they just discovered it. 99.99% of the things that these teachers are online teaching today are at least 35 years outdated. Asset versus identification. In the context of a mortgage or auto loan, a QSIP might be assigned to a mortgage-backed security, not your actual mortgage contract. A pool of many loans sold to investors. Finding this number does not give you ownership of the underlying investment or any hidden account. A QSIP number identifies it. And what do I always say? You have to be the registered beneficial owner of the mortgage-backed security or any other asset-backed security to be entitled to any proceeds from it. So by you finding a QSIP number on it does not give you any of those entitlements. Let me guess, it's mine. It came from me. Are you registered in their registration statements? Because if you were, you'll be getting dividends reports. You'll be getting a statement of account. From a security, if you was really, it comes in a few pages. It shows you the interest, the yield, how much taxes, it has that. But what you'll get is something like, let me see if I can find it. See, instead of getting a official account statement for your QSIPs, you won't get the official one. Y'all will get something that has probably like a red arrow going up. Right. That's fraud. Notice how you got many teachers that are teaching, that are selling the same QSIP with the red arrow. That red arrow, take a copy of yours because I know you bought one in the past. I know it looked like easy money to you. Quick, fast, easy money. I know you did. I know you brought one. They only was charging $200 for it. I know you invested $200 in it. Don't say you didn't. All you got to do is take a screenshot of that red arrow and then do a reverse search, Google Lens on it, and you're going to see all the official companies that use that arrow. So they took that off an official document and they place it on there. And then what they do is they'll find a CUSIP number. CUSIP numbers are not hard to find. The IRS has a section where you can find the companies with all the CUSIP numbers. It's easy. So what they did was they'll find a random CUSIP number, hoping you'll be stupid enough to not do a check on the CUSIP number. Because when you run the check on that CUSIP number, it's never going to come back to any account that is associated with you. It's always going to come back to some hedge fund, some fund manager, and 9 times out of 10, that fund has already been depleted. They've already received the proceeds. So it's only going to be about $7, $8 in it anyway by the time they sell that to you, that document. So then the numbers, those millions of dollars that they're saying, that what they found with the CUSIP report, they wrote those numbers in. They literally wrote those numbers in because a CUSIP would not give out that information. It just identifies a security. So ask them, how did you get this number just by pulling the CUSIP? The CUSIP just identifies a security. It doesn't show who's entitled to it. It doesn't show how much money it's worth. It just identifies it. And this is from going back to the recession of 1929. They instituted all these measures with the Securities Exchange Commission, just per the Securities Exchange Act. So people are going to take that number, the number that was created by the person who is selling that stuff to you. This is how low level thinking they believe you guys are. Like they don't even give you enough dignity to not even, like they're playing in your face. So people got excited about coming back and finding their millions, and it was all over the world. One thing about the birth certificate, finding the CUSIP on your birth certificate, and it was 5 million. It was people out of California was doing it, and it looked so real because it came in a professional package. So you got everybody's birth certificate that got 5 billion in it, right? Anyways, so what they do is they will actually file the tax return. They will actually file the tax return with all those hundreds of millions that the person who is selling the document typed in, made it up. And they will actually put that on a 1099-B. And then they will actually expect to get a refund from it. Now, there could be a few questions here. Who is more to blame? The person that sold that garbage or the person who actually believed that they was going to get any money out of it? A person who is financially stable would look at that like, what's the catch? Hold on. Something don't seem right. So you mean to tell me these people about to cash me out? A person who's going through financial troubles, they're just going to jump on it because the only thing they see, this is a way for me to get out my situation. That is the problem with these spaces. The mindset of the people coming through the door. Now, finish reading it. Oh, yeah. Oh, hey, what's up? What's up, homie?
Yeah, you got it.
Hey, what's up? Yeah, I just wanted to let you know that we got a class. We have a class tonight in the Set U, but I also wanted to get on the phone with you sometime this week because I know I know want to go over some things that we talked about a couple weeks ago. I was busy, but I got a little free time on my hand. And I also want to, yeah, I got you. Yeah. And OG too. Let OG know that we all gonna get on the call too. And he probably back in the hospital. Shit. I need to get in touch with him, bro. We need to get in touch with him.
Okay. Yeah.
Oh. All right. All right. I'm gonna try. We gotta try to call his son or something. But anyways, we'll get to that. Also, I got some questions that I run by your your people that work for the accounts management. Yeah. I got some. Yeah. So I got some things I want to run by you to run by to her, and just let me know what she say.
Okay.
All right. So let's schedule something for sometime this week.
Okay.
All right. I got you, broski. Yes, sir.
Just let me know, man.
Oh yeah, and I'm gonna call the other OG too, because I'm gonna need him to make I think next week to make the special guest appearance and set you. All right, so I'm gonna text it. It starts at 6, between 6 and 6:30. If you can't make it, I got the recording anyway. I got the recording Eastern time. Yeah. All right, you got the record. You have the recording in the group. All right, bet that. Yeah. My bad, TikTok. Hey, my homie called me back. But if you missed that, I just said, hey, we can get on the call this week because I got some questions I want to run by your your family member that works for accounts management at the IRS. And I want you to run that by her and let me know what she says. Just like when I need something to know about their internal operations, hey, yo, homie, the SEC attorney, hey, yo, text him this. Let me know what he said. See, those are the, see, that's the lane I'm in. That's who I got access to. I literally got access to people that work in high places in government and in the financial world. So my way of looking at things may be totally different from the rest of the people, from a lot of people. I look at things totally different. I don't follow the same just because everybody else is doing it. But anyways, a pool of more. So in the context of a mortgage or auto loan, a CUSIP might be assigned to a mortgage-backed security, MBS, a pool of many loans sold to investors. Finding this number does not give you ownership of the underlying investment or any hidden account. No tax function. CUSIP numbers are used on tax forms like 1099-B or 1099-INT only to identify which specific stock or bond generated income. They cannot be used in place of a federal tax ID, social security number. The risk of following this advice: the IRS and the Federal Trade Commission frequently warn against schemes claiming you can pay debt or get a refund using these numbers. Frivolous filing penalties. Filing a return based on these theories can result in $5,000 penalty for a frivolous tax return, in addition to any other taxes or penalties owed. Many websites or gurus offering to help you find these numbers are fishing for your information to commit identity theft. Criminal charges. Attempting to use these numbers to discharge debt can lead to charges of wire fraud or making false claims against the government. And just like Skip the Boss, he was stealing people's information. And if you think I'm lying, Skip the Boss, I got the email. You know that $3,000 you stole from 8 people? And then one called me saying that you just tried to access their bank account, and they froze their account right after giving you their information. Remember, Skip the Boss? Remember that threatening email that you sent to me, threatening me, how you was going to lean me or pull up, and I dropped my location to you, and I told you to pull up? You know I come from that world. I ain't go to the federal penitentiary for being for selling counterfeit Boy Scout cookies outside of Giant. And I told you we can, if you want to take it there, we can take it there. Remember? Okay. Oh, we can go up fast. You know. Tax scams. Tax scams and warnings. I stress this to my group with the IRS. Even if people be like, you know what, let's just try it. Like, I don't care if I get it frivolous, you know, I don't care. I ain't gonna blame you. I said, absolutely not. Absolutely not. I can't, no. I cannot put this claim in. You're asking me to file a tax return from $100 million based on some audit you got back. I can't do that. Absolutely not. I swear it's going to be better for you if we don't do this, because I already know what's going to happen. You're going to get hit with a tax bill that you wish did not exist. Scammers mislead you about tax refunds, credits, and payments. They pressure you for personal, financial, employment information or money. IRS impersonators try to look like us. Watch out for a big payday. If it sounds too good to be true, it probably is. And you don't need to know about the system to practice wisdom and discernment. That's given to all of us. But the greed, the desperation, the hunger to be more than what you are in this present moment in life. It's that inner greed. It's that, oh my gosh, with 100 million, I will be the man. I have so much power. I can do it. It's that. You start spending the money in your head. Everyone who received many, I'm going to say every because I don't know everyone, but many who received the check based on these frivolous, fraudulent filings either got hit with so much tax debts that they wish they would have gave the check back, or they went to prison behind it. All the money in their accounts got frozen. Their homes that they brought with it repossessed, vehicles repossessed, and all of them got hit with an 18 to 24 count indictment by the federal government. And what did all these so-called generational wealth people do? This is why I don't like the mindset of a consumer. Because many people that come into these spaces are only looking for money so they can be a bigger consumer. That's it. The people that got indicted last year with this Telegram group they had, filing fake frivolous tax returns, getting refunds. It was so good. 2023, 24, they was the place to be. I heard about the group. They getting refunds. They getting checks. And that's the only thing that people measure. Oh, you got a check. Oh, this person got a check. They're not looking at was it legitimate. Did they bypass the IRS controls? What did they use the file? When someone says, I got a check, I can give 2 rats asses that you got a check. I want to see, did you follow the rules to get the check? And they never do. And what did they go buy? Go buy a GMC Denali. Go buy a home. Go buy another car. Spend thousands at the mall. Where's all this generational wealth people at? I thought that was the big, they got what, almost like 4.2 million back. Where's the money going to generational wealth? Remember, that's what they tell you why I'm here? I'm here for generational wealth, claiming my estate for generational wealth. Shit ain't about generational wealth. This shit is about greed. Because they know they don't have the ability or refuse to go out there in a real world and make it happen. So they look for shortcuts through tax returns and frivolous documents and a state. They have to believe it's true. They have to believe it's true. Because if you take that away from them, what do these people have? What do these people have? Absolutely nothing. They will be stuck with the same miserable existence that they call a life.
You're rocking with the best.
Do you think I could bring this to some of my business partners? Do you think I could bring this stuff to some people in my inner circle? Do you think I can bring this stuff to one of my clients who clears $2.3 million a year after taxes? Do you think that person want to entertain this garbage? And they do it solely for the money. They're so desperate. They're so ruled by the love of the money that they will risk going to prison behind this Q-Sub 10-9. They will risk going to prison behind it. And if the IRS makes an error and send them a check, instead of doing the right thing, regroup, do it better, they're going to find ways to not send it back. And then they don't send it back. But what are they doing on the flip side with that money that would even make this risk worth it? It's not like, hey, yo, government, hey man, I know I was supposed to send that check back 3 years ago, but look, I made smart investments. It done blown up. Yo, can I give y'all $1 million? Hey man, I did this with it. Hell, government, at least I brought government securities with it. Here, y'all can have that back. Y'all don't do nothing with the money. Person get a $100,000 refund from 2021, 2022 for their auto. What do they do with the money? Nothing. They do nothing with it. So what do? They go think they can rinse and repeat again because it's always going to be there. They don't do nothing with the money when they get it. What gurus out here got investments? Real live investments. What gurus out here got real live investments? Got investment property. What gurus, like, who's really investing in their kids' future? Who got insurance plans, life insurance for their kids? Who got college funds started for their kids? All these gurus would pull the fucking curtain back. What's going on in real life? Nothing. Nothing. Hate their job. Can't stand their existence for real. This process is nothing but an escape from reality for most people. What's good, Top Cat? OG. That's the OG. OG, you know about investments. You got investments. OG, do you think, OG Top Cat, would you ever try some BS like this? And risk your family, risk everything you worked hard for to stop playing games with the government like this? Would you? No. I'd rather you be piss poor broke and studying to do things the right way than try to leapfrog and take a shortcut. Because the reality is everybody thinks they're going to be a millionaire out of this. And the reality is it's not going to happen. Everything I've accomplished since November 6, 2020, I did this. There was times where I see people, I'm at the bus stop, and I see people riding around their Benzes, and their time be like, damn, sure, I wish I had a vehicle right now. But I was like, you know what? I'm about to really get on my game. I'm about to really hold it in. People are so scared and afraid of failing that the things that they do brings them closer to the failure that they fear. They are so scared of failing that the things that they do brings them closer to the failure that they fear. People are so scared of losing in court that they just take measures to avoid and hide the fact that they know they're not ready for court. They know they're not ready for it. You have to be prepared to lose when you go into court. And guess what? Nobody wins them all. There's going to be cases that I lose. That's the game. There's going to be cases that I lose, probably in the future. I don't know. Of course, you want to win them all, but we know that's not the reality of court. You're not going to win them all. You just hope that you win more than you lose. And every time you win, you don't get comfortable. Y'all are comfortable. You're comfortable with these packages. You're comfortable with these $50 ebooks. You are comfortable. You can crack open the stream and tell people to file this and do this and do this. You're not doing it. You're not doing it. You're not leading by example. And it's getting to the point where I got to start questioning everybody's so-called success. I got to start questioning it because it's always shrouded in some type of mystery, or it's always not in a way that is being presented. And many wins that I see from people out here today is all technicality wins. I have yet to see someone go into federal court and win or at least settle off the merits of the case. Everything is a defensive posture. Everything is defend, defend, defend. If they're suing you, if they're suing you. If I'm saying, why are you being sued in the first place? Ask yourself that. The answer can't be, I found out they're violating the law, so I stopped paying. That can't be the answer anymore. Because what gives you the right to stop paying? From a legal standpoint, what gives you the right? I'm not talking about a doctrine. I'm not talking about a maxim. What gives you the right to stop paying from a legal standpoint? What statute or case law that says if such a this happened, you don't have to pay anymore? How can you justify not paying from a legal standpoint, from a binding contract? Does the contract say if they breach this, you don't got to pay anymore? How can you justify that from a legal standpoint? If you can't, you're making a big mistake by just unilaterally just stop paying. Or you stop paying and the lawsuit is imminent. Let me see. So what's another one involving new scams involving W-2 wages? One scheme which is circulating on social media, y'all, they come straight to, I'm not gonna say that name, but for y'all that are listening on the voice chat, this is where they come. They come straight here. So they see the scams that are being taught. I don't like to use that word on it, but they see the stuff that's being taught on here, and then they go back and get prepared for it. One scheme which is circulating on social media encourages people to use tax software to manually fill out W-2 wage and tax statement and include false income information. In this W-2 scheme, scam artists suggest people make up large income and withholding figures as well as the employer it is coming from. Scam artists then instruct people to file the bogus tax return electronically in hope of getting a substantial refund, sometimes as much as 5 figures, due to the large amount of withholding. Along with the Security Summit, partners in the tax industry in the states are actively watching for this scheme and others. In addition, the IRS works with payroll companies and large employers, as well as the Social Security Administration, to verify W-2 information. So if you online and you see this type of process, you know what time it is. We, with National Consumer Protection Week starting Monday, The IRS and Summit partners warn people not to fall for these scams. We are seeing signs this scam is increasing, and we are worried that innocent people could be at risk of being tempted into falling into a trap that puts them at risk of financial and criminal penalties, says Acting Commissioner Doug O'Donnell. The IRS and Security Summit partners remind people there is no secret way. The IRS and Security Summit partners remind people there is no secret way to get free money or a big refund. Now clip that.
You're rocking with the best.
There's no process that you can do to get a large refund. There is none. Anyone that's telling you different, the IRS is telling you that they're scammers. Let me say it again. The IRS and Security Summit partners remind people there is no secret way to get free money or a big refund. People should not make up income and try to submit a fraudulent tax return in hopes of getting a huge refund. You see that? You see what I'm saying? But no. I'm the bad guy because I'm telling you to not fall for it. Bad advice on social media can mislead you about your credit and refund eligibility. Influence may convince you to lie on tax forms or suggest the IRS is keeping a tax credit secret from you. Social media posts may put you in touch with scammers. This is from the Internal Revenue Service. One thing about the IRS, if you're entitled to it, you are entitled to it. If you're not, you're not. The Internal Revenue Service issued a consumer alert today, May 14, 2024. And I was trying to warn people 2 years ago, y'all, them large refunds, it's not legit. I know I got the check. It just means you bypass the internal control. They're going to double back. Y'all don't know the IRS accounting system from the internal side like I do. They run just like a financial institution. The computer generates a refund. They don't sign off on the refund until months later because they're just taking your word for it. But when they double back and check the books, this is when you get a letter talking about, hey, there's an error. Now you owe this. We need that back. They don't check it right then and there. A 846 is a computer-generated refund. The computer generates it. The examinations puts eyes on it afterwards. They don't have all that time to do that for every single woman. They got 80 million pieces of taxes to come. That's why some slip through the cracks. But that's not a success. The IRS warned the Internal Revenue Service issued a consumer alert today following ongoing concerns about a series of tax scams and inaccurate social media advice that led thousands of taxpayers to file inflated refund claims during the past tax season. This is back in 2023. Like I told y'all, these 2021, 2022, 2023 teachings. This is why it's been quiet last year. This is why I start to sizzle down in 2024. This is why it's quiet last year. And this is why it's going to be dead silent in 2026. None of that is getting through. The IRS warned taxpayers not to fall for these scams centered around the fuel tax credit, the sick and family leave, household employees, and they got another one. They got another one for exactly the 1099B scam. They got one for the exactly the 1099B scam that actually is what they be online still pushing around. They was really pushing for that. Woo, when were they pushing for that? Like 2023, 2022, 2021. Remember that? All right. Let's see. Can we get out of this? So the IRS lists its dirty names. Why does it make me? Okay, let me get out. I'm gonna get out of this one. They say I need a membership, but I'm going to show y'all the 1099B tax scam. Show y'all. And this is going to be the same thing that they're going to be online teaching about. They're going to be teaching about this stuff. Let me just put that down for a second. Let's go. All right, so you got over social media. Here we go. Tax scam. Okay, so here we go. This is one of them, but let's go right here for a second. So it says right here, social media. Where I just at? Oh, overstated withholding. Social media schemes encourages people to include false income withholding information on these forms: W-2 and WG, forms 1099-R, 1099-NEC, 1099-DIV, 1099-OID, and 1099-B. And 1099-B. Yeah, the IRS just dropped their dirty dozen. I always, as soon as it drops, I always download a copy. These schemes suggest people make up large income and withholding amounts in fictional employers, then file the tax return electronically. The aim is to get a big refund due to the large amount of fraudulent withholding. Vincent Edwards. So when you got your 1099-B and then your 1099-B with the withholding, and then the 10 times the amount because the Federal Reserve, fractional reserve system, modern money mechanics, huh? It's a fraud. I don't care. I don't care if what you show. It's a fraud. It's a fraud. Let me hold on. Let me find the website. It's been a while. And it's all about the withholdings. It's all about the withholdings. That's it. That's all what it's about. It's all about the withholdings. It's all about the withholdings. Here we go. It said it right here. The overstated withholding scam is a scheme on social media. The overstated withholding scam is a scheme on social media, encouraging people to use tax software means to complete W-2 tax statement, other information returns, including 1099-B and OID, to include false income and withholding information. However, the IRS verifies the withholding claimed on tax returns. The IRS will freeze the tax return for further review if it cannot verify the wages, income, or other withholding credits entered on the tax return. The IRS will send you a notice CP05A requesting additional documentation to support the wages and withholding report on your return. You will not receive a refund if you cannot provide this documentation. Now, how you going to justify that? What you going to say? Huh? How you going to justify that? How are you going to justify that from what you taught in class? because you're taking the class. You're taking the class, right? You're taking the class. And what is the class teaching you? Execution. You're not learning about the tax laws, the regulations that govern it. You're not even going over the instructions, right? So when you actually file it and they ask you to verify this, when they ask you to verify it, how you going to verify it? From what you learned in class? And this is why people are taking it to get shortcuts so they won't be challenged because they know they won't be able to defend or stand on it. So they hope don't get challenged. Just do it and send me the money. I paid $1,000 for this. So I paid $1,000 for someone to teach me how to get 200, 300,000 back. And I've noticed that because I've seen some of the transcripts that people that was in this group sent to me. You know what is a common theme? The actual real income that was reported for that client to the IRS, it was always $32,000 income, $40,000, $38,000, $17,000, $25,000. I'm talking about actually in the IRS system. That's how much income they made this year. You see the common denominator with the real income they made that year. And then you go to the withholding amount, 150,000, 200,000. You know what the real issue is? And I say this with all sincerity, no malice in my heart. Only people that are in financial dilemmas and struggling financially are going to be quick to jump on these processes. Many people that follow those things do not make nowhere near as close to that money in a year. They don't even clear $15,000 in a given month. Talking about legitimately. They don't even clear 150,000 in a year, but they got 200,000 in withholdings. And guess what? Guess what? You want to know when the IRS first started talk about the 1099 scam? They've been talking about for a while, but the 1099 first they started talking about it in 2018. They started talking about this in 2015. They started talking about this for years back. And what people do, what does people do? Why can't I find it? What do people do? They still do it because their current situation, right? Their current situation, it's to them, it's worth it taking a chance. And once again, number 4 on the Dirty Dozens list is misleading tax advice on social media. Viral tax hacks can push taxpayers to file returns with false information or claim credits they don't qualify for, leading to refund delays, audits, penalties, or worse. The IRS continues to warn that social media-driven misinformation and disinformation remain a major driver of tax scams. What you see online. Oh, it's not showing? what you see online. Viral tax hacks can push taxpayers to file returns with false information or claim credits they don't qualify for, leading to refund delays, audits, penalties, or worse. The IRS continues to warn that social media-driven misinformation and disinformation remain a major driver of tax scams. See? 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 Overstated withholdings. Scammers encourage taxpayers to inflate withholdings amounts, sometimes described as other withholdings, to manufacture a larger refund by reporting zero or little income on incorrect forms. The IRS may delay processing while it verifies wages and withholding against third-party records. Inaccurate claims can lead to penalties and enforcement actions. There are multiple variations of the overstated withholding credit scheme, including those involving forms W-2, which I've seen online, W-2G, which I've seen online, 1099-R, 1099-NEC, which I've seen online, 1099-DIV, which I've seen online, 1099-OID, which I always see online, and 1099-B, which is now the leading force online. Telling you. I'm telling you. I'm telling you. And this is what they were teaching in that dude's class. When you file the large withholding on the 1099-B, they were filing as the payer in the bank's name. And then they were going on 1099online.com, putting like Bank of America. Like Bank of America. They were putting that. Matter of fact, I made a video on it. I made a video on it. This one was hilarious. And we're going to check, man, it's not legitimate. And I know they asked for it back. See, people think that they can use like money, like, oh, I got my. Next time I ask you to shut up, you do it. Let me show you. Let me show you exactly what I'm talking about. Oh, and for you, Admiralty legal beagles, you still ain't proved me wrong. Only thing y'all been doing is going in line, coming in the comments, stating you're wrong. That's wrong. But you're not showing me how I'm wrong from a legal standpoint. We watched at least 5-6 cases where everybody said, tried the Admiralty trick, and the judge kept saying, no, it's not Admiralty. We're not on the high seas. But now I'm wrong. So if I'm wrong, the judge is wrong too now. You see how these people think? Oh, before we get there, in case you forgot, I do the reverse search. This the QSIP. This is on my TikTok. This is the QSIP. The reverse search. All Forex signals, global, that arrow that goes up. This is what they're putting on your, on your fake QSIP report. So we had the content creator. The name's at the bottom of the screen on the left-hand side. I'm not going to say it. I was in her live. Marcia L. Smith. I think she blocked me from her live because just like everybody else, she showed up with the same QSIP number. She showed up with the same QSIP number with what? The same red arrow going at the top. And they got the QSIP number, but let's play it out. How much is that? 154,300,000 $67,000, $304,535,000 in net assets. It all says the same thing. It's fraudulent, but guess what they're going to do? They're going to put that on a tax return. And guess what? In their mind, they really think they're going to get a refund in that amount. And all they got to do is take 2 brain cells and rub them together, and they'll realize that none of that is legitimate. They're living in an alternative world. See, the sovereign citizen people and the people that are desperate, they think people like me don't understand nothing, don't know nothing, control. They don't even realize that they're the ones that live in an alternative universe. And she was saying this is a Q-sub from her CarMax or someone's CarMax auto financing. She's not knowing that I'd already exposed that these Q-sub numbers showing up on these documents are fake and it's a fraud and it's phony, but it says CarMax Auto. So I said, let me go do some research on that Q-sub number that's highlighted in yellow. And what I did, look at the results. Nothing about CarMax. It's like an energy company out of Texas. Nothing that says CarMax. But this is how little they think of people that listen to them. This is how little they think. He said, Inspector General of the Treasury had a great inspect. Yes, sir. I remember that one. But guess what? 10 years later, they're still trying it. All dealing with energy out Houston, Texas. Just look at it. Nothing to do with CarMax, because what they do is they'll go online to Fidelity somewhere, find a real Q-sub number, which is public information where the SEC requires based on the stock market crash in 1929, and they find random ones and they put the actual Q-sub numbers on there, but the funds that they come back to have nothing to do with what you're paying for. You're paying for a mortgage or auto Q-subs. They type those millions of dollars in there, all to get you to think that you're going to be entitled to the money that they typed up on the paper. Because you never get how much money. You just get the performance of it. You get the performance of the Q-subs. You get the performance, the net, the distributive shares. And when you actually are investors to these securities that have Q-sub numbers, they look like this. And right there, I'm showing a risk and performance detail. It's 5 categories. It's on my TikTok page. You just got to scroll down. Actually, I'm going to pin it. I'm going to repin it to the top. It's a total breakdown. Shares, this, all that intricate detail is never that one little document with the red arrow going up top. That's the biggest indicator to $200 for it. Right. See, and they come in pages long, giving you the full report. So what it boils down to is most people don't have a remedy on here. They don't know how to get it, and their only remedy is taking the scraps from the low-hanging fruit students and the ones who have a poverty mindset, and they're using the lure of you getting millions of dollars that you don't have now, so you don't have to work anymore. And that's how y'all biting the low-hanging fruit. Once again, I've dispelled another myth on here, and you will thank me later.
Wake up, wake up, wake up, wake up, wake up, wake up out of your sleep, wake up out of your sleep, wake up, I command you in the name of Jesus, wake up out of sleep, wake up out of your sleep.
No pressure, nah, I ain't feeling no pressure, no, I ain't stunning her, man, she wanna get on top of shit, I'ma let her.
That was the Q-sub. That was the Q-sub one. Now, oh yeah, so let's get to, here we go. I even called Q-subs Global in 2024. See if you know what he's talking about.
Thank you for calling CUSIP Global Services. Please make a choice after listening to the following options.
How you doing, sir? I'm calling because I have a question. Is this the only department of or corporation that can issue a CUSIP number? Is this the only authorized in America?
Yes.
Okay, so if anyone else does not work from this department, CUSIPs Global, anyone that's not affiliated, licensed, broker, saying that they have CUSIPs potentially for sale, that is totally should be raised suspicions.
Yeah, I mean, well,
Private individual, not a like a securities broker or, you know, in the securities film, you know, the financial world. We're just talking about a private person. Say, man, I got CUSIPs for sale.
We're the only ones who assign CUSIP numbers. But, you know, we have licensed CUSIP agents in other countries.
Oh, okay.
For example, you know, we have an agent up in Canada, Canadian Department
Okay.
of Securities. In Bermuda, we got the Bermuda Stock Exchange.
Okay.
But it all kind of gets funneled back to us anyway. So,
Right.
yeah, we're really the only source of CUSIP numbers.
Okay, and I would just, if I wanted to get a CUSIP for securities that I would like to issue, I would just follow the proper application procedure on your website.
Right, exactly.
Oh shoot, okay. Thank you, sir. I was just calling to do a little fact checking, man. There was just some private people, you know, getting people's money saying they had CUSIPs for sale, then people are going into banks and just getting totally humiliated. And I'm just trying to.
There's a lot of misinformation out there.
Yeah.
With respect to CUSIP numbers and just the CUSIP system in general. We get calls constantly.
Yeah.
All day.
Yeah.
About stuff that, you know, I don't know how this information gets out there.
Right.
There's people who, you know, they're calling about getting CUSIP numbers for court cases.
Right.
Their social security number. I mean,
Right.
you name it.
It's crazy.
Calls about it. So yeah, there's a lot of misinformation, but rest assured, we're the only source of CUSIP numbers. If you're interested in getting one, go on the application,
Okay.
fill it out,
Okay.
send it in, and we'll take it from there.
All right. And before I go, just to make sure, there is no CUSIP number that can ever be pulled from a birth certificate.
No.
Knew that. That was crazy. Would anybody even believe that? Thank you, sir. I appreciate your time.
You got it. Have a great day.
All right. Oh, yes, sir. So y'all, oh yeah, I got the dude Mike from. So yeah, I'm about to be doing a promo. I got a promo deal with where's the other one at? This can't be my whole page. Nah, there's way more to this. Okay, see, I'm on TikTok, so how do I get to the next page? I guess that's all it's allowing me to see for now. But I wanted to see all of the, I wanted to show you the one where dude was filing the tax return in the bank's name and then putting his, having this person send a copy, which bypasses the IRS system. And then inevitably, they're going to ask for the CUSIP number. I mean, ask for the return back. Oh, y'all remember this one?
Instrument that they filed and did not report on. So that's why I put it on the 1099-B, because the law says that I can get the cash back from
Because the law says
the converted instrument or other property or equal value or the approximate value of the stock. I can get it all. So if we pull a QCEPs at 347 million, then per the law, I can get it all back if I report it right.
You see that? That's Vincent Edwards saying, woo-wee, in that girl Victoria's class. I got the whole class. He's sitting there playing student. And then as soon as this was done, he went and started selling the same process.
That's the law. It says the term.
Oh my goodness. Like I said, boy, don't mess with me, boy. I got receipts on all y'all scammers. I know exactly your talking points from the panel that you wouldn't let me up on the other day. Everything you're saying on the panel was the same thing you learned from her. And none of that works anyway. I already had that confirmed. Everything in that class doesn't work anyway. Because your guru, she refused to have a live debate with me. She said yes first, but then she backed out. So stop playing with me, boy. I know where you get your information from. You don't study this. You do exactly what you do. Hop on lives, hop on panels, and then you pose as a student, then you run back and go sell that same shit that you just learned. You ain't doing no studying. You don't know if it works for you because you don't even do it first. You don't even be successful first because you got a gambling habit. Remember, you need that $1,000 execution class, right? And we know when you got the two 1099Bs on the 1040, you got it from this video too. Stop playing with me, boy. Tap out now. Tap out now, because there's more. Everything that you was teaching in your Discord class and people on TikTok, I guarantee you, I could find where you was a student not too long ago. And all you do is just go try to seek new information to run back to your group and sell. Stop playing with me, boy.
Doc, I came up.
Stop recording. Okay, hold on.
No, record.
Okay, so
Look at him. Record. Look at him. Being thirsty to go steal some fraudulent information.
I was showing Steve, excuse me, how to take his administrative process and get the clients paid. So
oh my God. You see, these are the people they follow.
I mean, he's telling me that it works for him. And sometimes the courts are asking for settlements, which means they're trying to get the last payment after you have basically rescinded your signature because they can't validate the debt.
So she's teaching to unilaterally rescind your signature. So that means they can't validate. This is all lies, man. It's BS. It's lies.
So I was telling them to make the administrative process go through fully, one must file a federal case, okay, against the company, which takes it into equity. The company is a fraudster, so they can't come into equity. Equity does not abet the volunteer. So that means that.
What did I tell you? They use maxims as it's the law. She didn't say equity. She didn't say per the court's procedures is not true. In case law, what did they use to support their claims? A maxim. A maxim.
They can't come into a federal courtroom at all.
So they can't come into a federal courtroom at all? They sure enough be coming in there all the time from what I see from the docket sheet, from the court records. They sure enough come in all the time. You see what I'm saying? This is what I mean.
So you don't see about federal courts. They're not listed on U.S. courts because that is an equitable court.
Oh, girl. Po child. Po child. And these are the people that knows it all. These are the people you can't say nothing to. They know it all. Congratulations, homie. I want to issue you up. This is the 1099B where Vincent Edwards, he filed one in the Bank of America's name and then filed the other copy with his client. This is what he filed, which is a fraudulent thing to do. Bank of America did not send them that. And he told on himself because Bank of America, their 1099s don't look in the way in which he filed the 1099. He filed it regular. Bank of America's doesn't file 1099s in their own selves. They file it through their brokerage branch, which is Merrill Lynch, who they acquired during the 2008 recession. Bank of America acquired Merrill Lynch. So if anything, the 1099 was going to come in the name of Merrill Lynch, because me and my wife, when we bought securities through Merrill Lynch, when we was with Bank of America, Merrill Lynch sent us our 1099B tax statement at the end of the year. And it did not look like the copy Vince Edwards filed. Apology, man. And it was the same year we was with Merrill Lynch in 2022. I mean, Bank of America 2022. I doubted you.
I really did. I didn't think it was real. I thought you was doing fraudulent withholding scams. I actually thought that you put this statement together and sent it to the IRS in Bank of America's name. But now, as March early this year, refund was issued. Yeah, I apologize, man. I really do. I apologize. But hold on. Hold on. My wife and I used to have Bank of America, and we actually received 1099 Bs from them before. Hold on before I finish this apology. Just hold on.
Wait a minute.
Because, you know, she actually brought stocks and stuff through Merrill Lynch. So I'm showing them now what how the real 1099 Bs from Merrill Lynch look like. I said, well, hold on. If you're getting a 1099B, that means you did some investment through their brokerage firm, Merrill Lynch. So Merrill Lynch, when they send you 1099 statements from the IRS, it looks like this with all of theirs. It looks like this. It looks like this. So then I started looking at the form again.
It's not who I am anymore.
And it looks like this. Number 2 is the 1099Bs you would get for your tax reporting. They don't send you the actual 1099s from the IRS. You just type them. No, they don't send it like that. And they never send it directly in Bank of America's name. It comes in the name of Merrill Lynch because that's Bank of America's brokerage firm. So I'm just trying to figure out, why do you keep trying the scams?
Wake up.
Told y'all, man. I can go on and on and on and on and on and on with these people. Nothing of what they're doing is anything that is remotely close to anything that is legitimate. All right, y'all. I got to get prepared for my Set U Class 4. Set U. Tonight is going to be the rundown. First 3 classes. Going to answer questions. We're going to dig a little bit into it. I'm still trying to give them like a day or two to finish up with class 3 video. That was a smoker. We dug deep into the principles of their internal accounting system. And why is all that important? It's going to be important when we get to the actual court side. How did all this translate into a viable court claim? So Set U University, if you're interested in joining Set U University, you can just send me a private DM or send an email to thomaslegacy603@gmail.com. Once again, we're going to continue to move the envelope. We're going to continue to revolutionize how consumers argue their transactions, their lawsuits, and we are not going to chase our tail, follow the pack. Everything we're doing is going to be groundbreaking, revolutionary, and won't be many people doing the same thing, because the amount of years and understanding that it took for me to even get to this stage, many of these gurus don't have the discipline, don't have the time, nor the patience, nor the understanding to put it together. What you see today is the byproduct of years of studying, years. It's not a fly-by-night, fresh out the pan. I'm very experienced in this world. But whatever, it is what it is. Let's get it. All right, TikTok.
Supreme Elite Team.
Session, yeah.
What? Thomas.
They studying the source now. Supreme Elite. New Empire talk. Came on reading numbers, they were reading memes. We was reading files, planning out the dream. Turn every late fee in the case law heat. Judge bang gavel, he don't skip a beat. They like how you flip stress into assets. How you turn a loss Thomas in the last check. Thomas took notes, broke codes, then he proved it. Now the classroom global and the language fluid. Thomas is the blueprint. Write that in the sky, let the crew print. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is the blueprint. Supreme Elite team, that's the school stamp. From the first lay bill to the full camp. New culture empire, watch the flag plan. Supreme Elite team, university. Turn the credit score into currency. Turn the closed door to a first key. Turn a side job to a legacy. He beat odds, then he beat litigation. Now we teach law like a new translation. From confusion into consultation. From survival into foundation. They log in, lights on in their eyes now. Section this, call that. They reply now. He like, know your rights, then apply now. God, that's the real drip. Let it dry now. Thomas is the blueprint. Write that in the sky, let the crew print. From the courtroom smoke to the new man. He designed the way we move our 2 cents. Thomas is the blueprint. Supreme Elite team, that's the school stamp. Wave it. From the first lay bill to the full camp. New culture empire, watch the flag plan. From the bench to the block, he reversed that. Put the power in the pen, yeah, he birthed that. Every mind that he frees, that's a verse that. Whole culture on the rise, you can search that. Hey, 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 hey. Thomas is the blue.